to the extent that there was a robbery, this robbery occurred at around 9:33 a.m. or 9:39 a.m. and that the shooting didn't occur until, 30-40 minutes later, 35 minutes later. I think the shooting occurred around 10:15 or 16 a.m. The actual armed robbery, or not armed robbery, but robbery by the victim of our client occurred around 9:39 a.m. And so there is a gap in time. And I would imagine that the state, based upon its requested charge of revenge, is going to suggest that in some way or another that Mr. Collier, after having been the victim of a robbery, should have calmed down within that period of time such that nothing that he did would have been justified. And so here's my response to that, Judge, is that simply by way of analogy, this court oftentimes rules on hearsay objections, as the court has done in this case. One of the exceptions to hearsay is present sense impression, right? The court knows that, right? And the reason why that is an exception to the hearsay rule is because courts have determined throughout the state of Georgia that when a present sense impression is a reliable testimony, even though it's hearsay, it's reliable because it is done at the time when the person is still suffering from the events of what they have just experienced, right? And most of the case law around present sense impression says that, about 1 or 2 hours, if you will, is enough to still deem a present sense impression reliable. Well, if that's reliable, Judge, then Mr. Collier is still under the impression or the effects of a robbery that he experienced, and that's less than an hour. And I would submit, Judge, that malice murder, when you have a victim who doesn't have clean hands, I'm not suggesting by suggesting he doesn't have clean hands, I'm not in trying to impugn his character. And by all accounts, I'm sure he was a good kid that was making some bad decisions. And so I will just say this: when you have a victim that has robbed the defendant, that takes malice murder off the table completely. And so now you raise the issue about felony murder, and I think it's an appropriate issue to discuss. I think I would have another motion at another time, if that makes sense, at the conclusion of our case in chief. And so I'm just saying, Judge, the state can't come in here and know their theory is, hey, the victim in this case robbed Mr. Collier. Mr. Collier was not the initial aggressor. There was nothing about those offer-up exchanges that reflected Mr. Collier was aggressive. There's nothing in this record that reflects that Mr. Collier was aggressive. The record reflects that they met up at the Wendy's and then ultimately the victim robbed Mr. Collier, which would be deemed provocation. And so by definition, this is not malice murder. And I would submit that the state has not and cannot carry its burden on malice murder based upon this record.
Mr. Lee.
We would ask that you deny the defense's motion. So in 17-9-1, we state that where there is no conflict in the evidence, and the evidence introduced with all reasonable deductions of interest therefrom shall be mandated. That is when.
Just speak up for the court reporter.
So I was citing as a 17-9-1. And it states that a directed verdict shall be granted when there is no conflict in the evidence introduced with all reasonable deductions and inferences therefrom. Your Honor, there is definitely, the state has presented definite evidence for malice murder for the case to go back to the jury. What the evidence we have is Mr. Justin Collier and Joshua Torrance discussing the purchase of a phone the morning of the murder. We have video of a shooting. You heard from Hannah Jones who saw that shooting. You saw video of that shooting. You have testimony that Joshua Torrance was shot in the back. Regarding whether or not this is murder or voluntary manslaughter, that would be for a jury to decide. Well, actually, I don't even think the defense at this time has presented any evidence to suggest at this time that a voluntary manslaughter charge would be warranted. What we have is an earlier taking of a cell phone and the state's theory that Justin Collier shot Joshua Torrance 30 minutes later in his back. And whether or not he may have said, give me my S back, there is nothing to suggest from that what Mr. Collier's state of mind was, whether or not that taking of the phone incited such a sudden and violent, irresistible passion that a reasonable person would shoot somebody in the back over a cell phone that was snatched from them. So, Your Honor, this is not a voluntary manslaughter. There is sufficient evidence to suggest that it is murder. There was sufficient evidence to suggest that Justin Collier was at the scene and committed the crime. We had the offer up record showing that he was in communication with the victim. We have the gray Kia registered to his mother, arriving during that earlier incident at 9:39, where the phone is allegedly snatched or taken in some kind of way. We have that same vehicle leaving the scene a little bit over a minute after the shooting. That the tag from the CVS drive-through shows clear and is registered to the defendant's mother. You have license plate readers put in the vehicle in the area before and after the homicide. You have the cell phone records putting him in the area of the homicide during the time of the murder. You have the day after, the defendant driving that same vehicle, doing the same thing, that is selling phones. There's a firearm box in the car with no firearm in it. You have ballistics evidence suggesting that the shell casing from the scene and the bullet retrieved from Mr. Torrance's body matched to a Glock firearm, which was the manufacturer on the gun box. So all of that evidence, Your Honor, viewing the evidence in the light most favorable to the non-moving party, we would ask that the court deny the defense's motion for directed verdict.
All right,
Just briefly, Judge, given that it's my motion, I'll just say most of what he said doesn't speak to the act of provocation by the alleged victim in this case. And that ultimately he was the victim of a robbery. We saw it on the film. The detective testified to it. That is an act of provocation. And to the extent that the state has submitted sufficient evidence concerning whether or not our client shot the alleged victim in this case, that goes more so to whether or not voluntary manslaughter is on the table. I'm suggesting that malice murder is the unjustified killing of another human being without provocation, plain and simple. There was provocation in this case. By definition, as a matter of law, malice murder should be, the court should direct a verdict of not guilty or acquittal on malice murder. Thank you.
all right. Thank you, Mr. Banks. But I do think the standard is sufficient provocation. And again, the context that we're in here in a directed verdict is to take all reasonable deductions and inferences in favor of the state's case. And so the arguments you're making, I think, will be quite relevant when we get to a charge conference. And they're ones that I really would like to sort through, because I could see it be going both ways, and we'll see where the case goes. But I think certainly the state has presented enough evidence to have the issue of malice murder get to the jury. Essentially, what's seen on the video itself, I think is a jury question of whether whether the defendant was acting with malice, which can be formed in an instant, or if there eventually is a lesser is included, whether there was sufficient provocation. All those seem like proper jury questions in a directed verdict context. So I would deny the motion as to directed verdict on count 1. And I think now we move on to the defendant's case, if any. So let me go ahead and advise the defendant at this point. Mr. Collier, I have a few questions for you.
Yes, sir.
Do you understand that you have a right to testify? And if you want to testify, then no one can prevent you from doing so.
Yes, sir.
Do you understand that no one can make you or compel you to testify?
Yes, sir.
That means you have a right not to testify if you don't want to.
Yes, sir.
Do you understand that not your lawyer, but you personally are the one who decides whether you want to testify or not?
Yes, sir.
And you understand that if you do not testify, then upon your request, the court will instruct the jury that your decision not to testify cannot be used against you. Do you understand that?
Yes, sir.
Do you understand if you choose to testify, you'd be cross-examined by the state and examined by your counsel?
Yes, sir.
Do you need any additional time to think about whether you need to testify or not?
No, sir.
And do you personally want to testify in this case?
Yes, sir.
All right. I find the defendant has decided to testify with a complete understanding of his rights. And let's turn now to the state's motion in limine regarding opening. There's not, again, I think as we alluded to yesterday, since this doesn't come up too often, I could really only find 2 cases on point when it talks about the defense reserving opening. And so I'm looking at Davis versus the state, 264, Georgia Appeals 221 from back in 2003. I've got copies if anyone wants one. Yeah, absolutely.
I believe I reviewed Davis.
All right. So in this situation, I don't think we're presented with what's squarely in Davis, which is it does appear that the defense intends to present evidence of some kind. However, there is some language in here that I think will guide consideration of the state's motion in limine, which is where it states, and I'm in section 2, so it's the bottom of page 2, where the Court of Appeals says that the purpose of opening statement is to give the jury and the court an outline of the evidence that the party anticipates presenting. And so that also, I think, tracks the language of the Uniform Superior Court rule. So again, a lot of this comes down to semantics and phrasing, but I would think that if the opening statement gets into an analysis or critique or something about what the state has already presented, that is, I think, would be an objection that's sustained. But if it's focusing on what the anticipated testimony of the defendant or others is going to be, then that seems appropriate. Or if it's going to be what the lack of what you'll hear by the time the defense is done presenting its case, which can kind of be a way to backdoor what the state has presented, if that makes any sense at all. But that's how I view this, but I'm happy to hear from both sides on that.
Obviously, Your Honor, the court has the discretion and ability to control the scope of both opening statements and closing arguments. And at the time that this motion was filed, obviously the state was unaware of what, if any, evidence that was going to be presented. And so that is why the state, out of an abundance of caution, filed this motion, precisely because I believe there's case law indicating that a reserved opening statement, when no evidence is presented, would be inappropriate because it effectively becomes a closing argument. Again, what the state is asking for in the motion is what you are outlining and what I believe you are directing counsel to do is that essentially not be referring to the state's evidence, but rather as to what defense counsel believes that the evidence that they expect to present through the testimony of Mr. Collier or any other witnesses would show. And so that was the basis for the motion in limine, so that we get ahead of that issue.
All right. Anything you want to add, Mr. Banks, or any clarity you think we need to have?
Well, I know I'm not entitled to 2 closing summations. And so I certainly understand and appreciate that. Had I given the opening immediately after the state, I would have been able to suggest what I thought that the evidence and testimony would show. And so, I don't think that I should be limited to just what our evidence will reflect during our case in chief, to the extent that I believe that the facts and evidence will demonstrate during the course of this trial that, for example, my client met with the alleged victim at the Wendy's. I don't know how that really harms the case.
I don't see an issue with that at all, as you phrased it. I think we're kind of clear on what it is. I think it's the cure determination to me is going to be whether it's forward looking or backward looking.
Right.
Because I think that's generally what an opening's all about. So, I think it's going to be up to how it comes out, and the phrasing you choose will invite interruption or it won't, and we'll see how it goes.
Well, I'm not.
Let's see if there's anything else to take up before we get into the state's case. Anything from the state?
No, yeah.
Actually, that reminds me, Hannah Jones, that was our Wendy's employee. At this point, we're ready to excuse her, Mr. Banks.
Yes, Judge. And just for the purposes of record, I've determined based upon my review, more thorough review of the audio footage that was provided to me, that I don't know if we ever circled back to what we were going to do with that, but I mean, to the extent that I moved for a mistrial, I don't think I did at that time, but if I did on that basis alone, I would withdraw that motion.
All right. Thank you, Mr. Banks.
Yes.
Okay. And with that, let's bring in the jury. We'll do our opening and we'll see how far we get with any defense witnesses. And we can always break in the middle when we get closer to 12:15, 12:30-ish, depending on how we're going.
All rise for the jurors.
All right, thank you. Please be seated, everybody. All right, the state has rested their case in chief. At this time, I turn to the defense and ask if you have any evidence that you wish to present.
We do, Judge, and I'd like to provide an opening statement at this time that I had reserved earlier at this trial. Court, please.
All right, you may proceed, Mr. Banks.
Thank you. And please support counsel. Ladies and gentlemen of the jury, good morning. Again, my name is Gabe Banks, and I have the pleasure, alongside Mr. Walker, of representing Mr. Collier in this case. I think the facts and evidence from our perspective will demonstrate during the course of this trial that the theme of this case really surrounds a very familiar saying. For every action, there is a reaction. Right? Sure, many of you have heard that. For every action, there is a reaction. I didn't get to the South until ultimately the 90s in Nashville, Tennessee, and then ultimately here in Georgia till 2005. But there are a lot of Southern sayings that I have come to love and appreciate. One of which is, you can't throw a brick and then hide your hand. That is what this case is all about. And that is what you will hear from the testimony and evidence from that witness stand. This wasn't about revenge where something happened weeks ago or months ago or years ago, and someone is plotting and scheming on a daily basis to try to seek out revenge. We're talking about the same day, within the same hour, facts and evidence will show, ultimately, the victim in this case, who according to his own family members, facts and evidence will show, had a history of robbing people of cell phones, ultimately robbed our client. And as a result of that, our client responded. For every action, there is a reaction, and you can't throw a brick and hide your hand. And I want to talk to you about what I suspect the evidence will testify, will be in this case. And so, one, I want to talk to you about Justin Collier. He was born and raised here in Georgia and graduated from high school in the Decatur area. And in May of 2018, he was attending Georgia State University. He was a college kid. And at some point, you will hear that his parents were helping him out with school, incurring some of that financial burden that parents do, as well as his brother. And, you know, as a young man, 18, 19 years old, you start to get that urge that you don't want to become a financial burden on your family. And so you kind of figure out whether or not you can develop a side hustle that'll put money in your pocket, right? And so he developed a side hustle. And a part of that side hustle was buying phones at a very discounted rate from various websites. He would pay sometimes $50 for the phone. He would pay sometimes $100. I venture to say he may even pay up to $150 for a phone. There were some issues with the phone. Sometimes the phones were damaged and cracked, right? Sometimes the phones looked like an iPhone, but they really weren't, but they were disguised like an iPhone. He didn't really care about all that. He wanted to make some money. And ultimately, he wanted to be able to put money in his pocket so that he could put gas in his vehicle, so that he could enjoy college life as a student without having to go home and asking mom to rob Peter to pay Paul, just asking for a few dollars. And so that's what he did. And in fact, prior to May of 2018, he was doing this for several months and making several $100s on each transaction so that he could, do some of the things he wanted to do. And I will submit this, the facts and evidence will demonstrate that he did it without issue up until May 30th of 2018. That there was never a time that a conflict arose, that there were no issues of violence in his history, that he's not some gun-toting thug that is just out to shoot at somebody, right? But instead, ultimately, he was selling phones for several months prior to May 30th of 2018 as a college student to put extra money in his pocket without issue or complaint. Now, did he have a gun on him when he went to purchase these phones from the various sites, whether it was Craigslist, whether it was WhatsApp app? He did. And he never intended to use the gun on these purchases and these sales, but he had the gun for protection. Why? Well, he had the gun for protection because facts and evidence will show is that he was going to locations that he was unfamiliar with. He's from Decatur, and when he would purchase and buy a phone, sometimes it would take him to locations, frankly, he was unfamiliar with. And so, as a means of protection, he would arm himself with a gun. Not that he intended to ever use it, but instead to protect himself if something went down. Georgia law, facts and evidence will show, recognizes that someone can carry a gun to protect themselves. And I'm sure we've all heard the stories at some point of someone being robbed off of Craigslist or some other site that reflected they met somebody even in a public location, and they became the victim of a robbery. And so he had a gun for protection because not only was he going to areas that he was unfamiliar with, right? He was also meeting with people that he had never met before. Doesn't know what their intent is, doesn't know what they have. And I will submit this: when you're going to an unfamiliar area and meeting with people that you don't know, protecting yourself, arming yourself with a firearm is not a crime. It's just not. And so that's what he would do. And he would do it without issue up until May 30th, 2018. So I want to talk to you about that. Facts and evidence will show is that on that day, he woke up at his girlfriend's house. And it was like any other day. He was trying to, utilize his side hustle to get extra money. And so he had posted a phone up on OfferUp. And when he woke up that morning, he received a signal and ultimately responded. Interestingly enough, the facts and evidence will show is that he had an OfferUp account and it was under Isaiah Goggins, right? And the facts and evidence will also demonstrate that the person he was communicating was Brad Williams. Well, he will tell you why he masked his name, because frankly, he doesn't want his identity known to people that he met with. This wasn't ultimately a time for him to develop a friend or to develop a relationship with someone. He was conducting a business transaction. And once the business transaction is over with, there would be no need for him and that person to communicate anymore, right? Facts and evidence will show he was communicating with Brad Williams. Well, Brad Williams was, in fact, Joshua Terrence. And so they're communicating, and ultimately they agreed to meet at the Wendy's. And when he pulls up to the Wendy's, the victim walks over to his car, and eventually they start to communicate. And even prior to walking up to the car, there were some text exchanges through the OfferUp app that reflected the alleged victim in this case was asking some pretty appropriate questions. One, the phone has to be unlocked, right? Is there an IMEI number or a serial number associated with the phone? And those are all questions that put my client in the frame of mind, okay, the guy's kind of serious about buying this phone. He wants the phone unlocked. Because generally what you will learn during the course of this trial is that when a phone is exchanged during this transaction, the person who wants to purchase it wants to make sure that the phone is a working device. And so half of the reason why they're taking so long at the car is because at that time, according to the facts and evidence, the alleged victim in this case was trying to determine whether or not the phone was operational. Makes sense, right? If the phone's not operational, I'm not about to give you several $100s for the phone. But if the phone is working and ultimately it's unlocked and I'm able to call somebody from the phone and the phone looks like it's in good and decent order, then I'm willing to spend some of the money. And so he posted the phone up on OfferUp for approximately $600. And ultimately, the alleged victim indicated that he was interested in that and asked some questions. And so they eventually meet at the Wendy's. Okay, what happens at the Wendy's? When he gets to a Wendy's, exactly what I said. And that is, he starts to say, hey, let me see the phone. And ultimately, my client hands him the phone. Interestingly enough, at that time, the alleged victim, you will hear, produced the cash and reflected that he had enough money to pay for the phone. And while he's checking out the phone, he keeps the cash, puts the cash back in his pocket, right? And then he starts checking the phone out, looking at the camera, ultimately making sure everything was in working order, and eventually made a call from the phone. And he did it by taking his SIM card of his phone and placing the SIM card into the phone that ultimately he was trying to purchase for my client. And once he inserted the SIM card into the phone, he was able to make a call. And my client will testify and say, hey, he made a call. I heard him talking to the person and saying, essentially, hey, I just wanted to call to make sure the phone was working. And it was working. And while they're doing all of this, they are having a normal conversation. My client is armed. He has a gun in his right hoodie pocket. It's not visible or anything, but that's where he keeps it during these transactions, just in case something goes awry or amiss. And they're having a normal conversation to the point where my client starts to feel very comfortable with them. They talk about where they're from. My client indicates that he's from Decatur, and he talks about how he just graduated high school, the alleged victim did. And then when my client says he's from Decatur, he told him he was going to Georgia State, and then they started talking about girls, like most guys do at that age. A normal conversation, nothing awry or amiss. Just a normal conversation while they're checking out the phone. And then eventually, at some point, to my client's surprise, after he's looking at the phone, the alleged victim snatches it and just runs away. So my client's like, okay, I mean, this has never happened to him before, right? And at that point in time, he's kind of in a state of shock. I think the video will show that he doesn't pull off right away, but there's a pause. And eventually he pulls out and he tries to go after his phone. And I mean, the judge will instruct you at some point during the course of this case.
Objection, y'all. I don't think we're in that part of the proceedings yet.
I'll sustain that for now, Mr. Banks.
Well, let me just say it this way. At some point you will learn that my client doesn't have a duty to retreat. If he's robbed, he can go after his property. That's just bottom line. There's nothing unlawful about that. Someone takes your wallet. I mean, you get a right to go after your wallet. Someone takes your purse. You facts and evidence will show you have a right to go after your purse. And so that's what he did. And he did it with no intent, ultimately, to try to harm the alleged victim. Now, was he ready to fight the victim? Probably so. But did he feel like at some point shooting a gun was necessary? I don't think he did. And I think you'll hear from him. In fact, facts and evidence will show that when the phone was grabbed, it's not like Mr. Collier does anything at that point in time, right? He could have exited his car and started to fire at the victim if he wanted to. He was certainly armed. Didn't do that because he just wants his phone back. Why are you taking my phone? Why are you trying to hustle a hustler? And so when he pulls out of the Wendy's in the same direction as the alleged victim in this case, he takes a right-hand turn. Well, that right-hand turn leads to the apartment complex of the Peaks of MLK. And that's the direction where he saw the victim running, right? And so he goes into the apartment complex and eventually parks his car, and he wants to find the alleged victim in this case. He wants to try to get his phone back. And what you'll know and understand is, look, I think the facts and evidence will show that people aren't robbing people without guns. Because as much as they're successful at the robbery, if they remain in the same area, the reality is that they may have to deal with the aftermath. And so does my client see a gun at the time of the robbery? No. Does he have to think that somehow or another in his mind that the victim may have a gun? Of course he does. And so as he's looking for the victim in the apartment complex to get his phone, he eventually finds the victim. But he's with a firearm at that time. And before he finds the victim, it takes some time. He's searching for about 10 or 15 minutes trying to look for him. He's in this apartment complex and he can't find him. There are probably about 6 or 7 buildings in the apartment complex and he can't find him. And eventually he just gets back in his car when he can't find him and chalks it up as a loss, right? And so as he's leaving the complex, that is when the victim, alleged victim, I would say, comes out and he's dressed in a whole different shirt. And so my client sees him and says to himself, man, this guy's in a whole different uniform, but that's him. That's the guy that just robbed me of my phone. And so at that time, my client's in his car and the victim literally walks by his car. My client honks at him and then exits his car and says, hey man, give me my phone back. At some point, you will hear that the victim said some words to my client. Importantly, at the time that my client said, give me my phone back, he was armed with a gun. He was within 10 or 15 feet of the alleged victim. If he wanted to pull out his gun, he will tell you that he could have he could have shot the victim point blank at that point in time. But again, he's not intending to use his firearm at that time. That's not what his intent is. He got robbed. He's trying to get his phone back and he'll call it a wash. He may fight the victim, but at some point his gun is there to use for protection, but he's not intending to use it if he doesn't have to use it. And so the victim says some things to the effect, F you, and walks on his way. And then the facts and evidence will show that he walked through, ultimately, the Wendy's parking lot, the back of the Wendy's parking lot. And so, and the person that you see in that video is my client, and he's following after him. He has clear range of sight. He could have shot him from where he was standing, where the car is. He didn't. He starts to chase him. He's trying to get his phone back. I will submit this to you. When you have a gun, you don't have to run. Guns travel at the speed of light. Bullets travel at the speed of light. There is no reason to chase the victim down if you intend to shoot him in the first place. And so as he's running, at some point, what you'll hear is that he heard a gunshot and he saw the victim reaching back. And ultimately, he fired in return. He fired once. And he'd never fired his gun at anybody. I think if you look at the video, it reflects he's firing it in a very strange way. But he fired because the victim fired at him. It's not like he unloaded his clip with several different shots. He fired in response to being fired upon. And at some point, he left. And he went home. And I will submit that at the time after he fired his shots, he didn't even know that he hit the victim. Didn't know it. Victim keeps running. Doesn't know he shot him. And frankly, I think he'll even tell you that he wasn't even trying to kill him. But he fired his gun nonetheless because the victim fired at him. And so when he gets home, at some point, he just goes to bed, goes back to his girl's house, and look, he wakes up the next day. I mean, there's no indication on anything to his radar that somebody died as a result of that, or that he even shot somebody. And so what do you find him doing? He's going back to his same hustle. Doesn't have his gun there, had left it at his girl's house, and ultimately he's selling phones again. And I believe that's what the facts and evidence will demonstrate throughout this trial, that our client shot in self-defense after the victim shot. And throughout this case, I just ask that you keep an open mind, that you listen to the testimony that we present. And ultimately, at some point after we conclude, I will get back up and ask you to return a not guilty verdict on all counts of the indictment. I appreciate your time and attention. I know jury service is always done at an inconvenient time. The fact that you guys responded to the summons is so incredibly important to our system, and we can't do what we do without all of you. And so I look forward to working with you. Thank you.
All right, Mr. Banks, defense can call its first witness.
Sure. The defense would call Justin Courtroom. Over there, right? Thank you.
Just a moment, actually, let me check it with the jury. So at this point, members of the jury, I think it may be an opportune time to break for lunch. And so seeing some nodding heads, then that's what we'll do. So let's take an hour. We'll be back in the jury room, 1 o'clock, ready to go. And as I remind you, and I will remind you again, please do not discuss the case with anyone or even amongst yourselves at all. And do not do any research about the case at any point. Thank you.
All right, for the jury.
Anything to take up before we break, Mr. Lee?
No, Your Honor.
Mr. Banks?
No, Judge.
All right, see y'all at 1.
Thank you.
So, amen.
I'm using the, yeah.
Should I give you the record of my phone getting stolen? Well, because I know you're not planning on them asking me, but. I think you're supposed to email it to. Uh-uh.
Just a reminder, guys, we're still on YouTube.
What she said?
She may have been able to hear us, but we can't put it.
Yeah. Deputy, do you know if our jurors are back?
Get y'all back and then double check.
Okay. Missing one. Okay. All right, you ready, Ms. Bowman? All right, let's go back on the record. I've been informed that all the jurors are back from lunch. Is there anything we need to take up before we get into Mr. Collier's testimony? Mr. Lee?
Yes, Your Honor. In anticipation of Mr. Collier's testimony, he's reviewed some jail calls that he reviewed a summary of some pertinent jail calls, and apparently in one of them, he says he's innocent and didn't shoot anybody.
I'm sorry? Okay, I caught that.
Okay, so we're in the process of, we have it on our like electronic cloud, but we haven't reduced it to like a form, CD or anything yet.
That you could tender.
Yes, but I can tender it and produce it later. So I have it available to play if that's what's in fact on the call. But I just wanted to alert for that.
All right, and so other than that kind of logistical hurdle, any other issues?
No.
All right, Mr. Banks, anything on your end?
No, Judge.
So my thought is if the call becomes relevant and admissible, we could go ahead and tender it, get through any objections that there may be, and just provide the physical copy later, either electronically to Ms. Pulliam or as a burned copy. So we're not just waiting on that to be downloaded. You could then publish it and use it in any manner as if it was already tendered as its own independent physical copy. Is that fair?
Yes, sir.
Does that make any sense?
It does.
Okay, Mr. Banks,
Play it now, burn it later.
essentially.
Okay.
Was it produced initially?
Jail call.
Well, I know some jail calls were produced, but he spent 8 months in custody before he was granted a bond. So I'm not sure of the timing of the jail calls. I would have to look at it more. I mean, if it's something that is just now being produced, obviously I would oppose it. But at the end of the day, we'll get to it when we get to it. I mean, we can start on his direct at this point. So
Okay, well, let's do that.
court, please, if I can stand at the end of the.
Wherever you'd like, the well is yours.
Thank you.
All rise for the jurors.
All right, thank you, everybody. I believe before we broke, we had not yet sworn Mr. Collier in, so why don't we do that now?
Raise your right hand. Do you swear or affirm that the testimony you're about to give to the courtroom is the truth, the whole truth, nothing but the truth?
I swear.
You may be seated. State your first and last name, spell it out, and speak clearly into the mic.
Justin Collier, JUSTINCOLLIER.
Mr. Collier, how old are you?
Right now I'm 24.
Okay. And back in 2018, how old?
I was 19.
Okay. And tell the jury where you were born and raised.
Okay, so I was born in Decatur, the east side, and I went to school at Southwest DeKalb High School, and I went to another school called Martin Luther King High School, and that's where I graduated from.
What year did you graduate from high school?
2016.
Okay. And do you have any brothers and sisters?
Excuse me?
Do you have any brothers and sisters?
Yes, I have one brother.
Okay. And at some point after high school, did you go to college?
Yes, I was playing basketball in high school, so then I went to another college called Middle Georgia University to play basketball there. That then ended up working. So then after that, I went to Georgia State University.
At the time of the incident in question, were you at Georgia State as a student?
Yes, sir.
And what were you studying?
I was studying business.
Okay. How were you paying for school?
I was paying for school through financial aid with my parents.
Okay. And at some point during school or prior to being enrolled at Georgia State, did you develop what I call or refer to as a side hustle?
Yeah, I developed a side hustle. Pretty much, I was just asking for money from my parents all the time. Just being a freshman in college, you just being out for the first time, it starts to get annoying. So with that being said, I just, found out how you can buy different phones from different apps like OfferUp, Craigslist, Facebook Marketplace. And then, you could sometimes just buy them for low or buy them if they're broken and then, just sell them for high.
Okay. And is that what you doing back in 2018 prior to this incident?
Yeah, I was doing that. I started about 6 to 7 months prior to it.
Okay. And what sites would you go to purchase the phones?
I would go to Facebook Marketplace, Craigslist, and OfferUp, and another app that I used to like a lot called 5 Miles.
And what would make you determine what phone you wanted to purchase? How would you go about making that determination?
Really, the price. I would do a filter at the top when you do a search, and I would do anything 200 below that matched the iPhone that I wanted to sell. And if it was repairable or unlocked, I would try to buy it. And do my renovations and go ahead and sell it.
Okay. And when you say repairable, were the phones that you purchased damaged?
Yeah, cracked screens. Really a lot of cracked screens on front and back.
And when you say unlocked, what do you mean by that?
To see if the phone is actually unlocked by a carrier. The carrier has to either unlock your phone or they just have to unlock it.
Okay. And so you would look for phones that were on the low,
Mm-hmm.
and then you would look for phones that were damaged.
Yeah.
Would you then purchase the phones?
Yeah, I would purchase the phones cash. And then, I would just go back on Facebook Marketplace and put it with, and basically just sell it for market value.
When you purchase these phones, where would you go?
I would only like to sell, purchase?
Yes, when you purchase the phones.
When I purchased the phones, I would only meet people in public places, just places that were safe and that was secure, that had cameras.
Were you armed when you purchased when you purchased these phones?
Yeah, sometimes, but sometimes I wasn't.
Okay. Why were you armed at times when you purchased these phones?
Because there's a lot of places that, in Atlanta, it's hard to tell what place is a safe place. So there's a lot of places that were kind of fishy. Like a lot of places on the south side, a lot of places on the west side, kind of fishy. So just wanted to, protect myself.
And I know what you mean by fishy because you and I have talked. I'm sure the jury may understand it, but for the purposes and clarity of the record, tell them what you mean by fishy.
High crime rates, a lot of Jays walking the street, just a lot of crime rate, a lot of drugs and everything in that area.
Okay. When you would sell the phones, where would you sell them?
At a public place as well.
Okay. How did you go about selling the phones, Justin?
So with everybody to make sure that they were serious, before I even let anybody take out a SIMS card, I would check something called the IMEI number. If you check the IMEI number, it's like a website that you have to go to pretty much tell if the phone is active. And then if the phone is active, then that's how you know that it's right to put in your SIMS card at that point.
Okay. And did you have what is called an offer up account?
Yes, I did.
Okay. When did you develop that account and how long had you maintained?
I developed that account probably 2 to 3 months prior. And yeah, I maintained it good. It was an offer up back then was very popular. I was selling to a lot of people with no problems at all.
Prior to 2018, on the occasions that you would have your gun, did you ever have to use it?
No, I never used my gun.
When you would take a gun, did you ever intend to use it?
No.
Why not?
Because honestly, I mean, I'm not about that life like that for real. I mean, I'm not that type of person. I like to do good business. If me and you can look eye to eye, we can do good business, shake hand in hand, and we can finish the transaction. That's all I need.
And prior to 2018, did you do that without issue?
Yes.
Did you ever have to use your gun prior to 2018?
I never had to use my gun before or after.
Did you ever have to confront anybody or get in a physical altercation prior to 2018?
No, sir.
Did anybody ever rob you of your phone prior to 2018?
No, sir.
But you still would take your gun from time to time?
Yeah, from time to time.
Okay. And that would depend on what, again?
Just the area it was at.
Okay. And so I want to turn your attention to May 30th of 2018.
Yes, sir.
Do you recall that date?
Yes, sir.
How old were you at the time, Justin?
19.
And at some point on that day, earlier that morning, where'd you wake up that day?
I woke up at my girlfriend's house at 112 Cortland. I used to live on campus at Georgia State, and it's like student dorms.
What's your girlfriend's name?
Shayla Reed.
Okay. And so you woke up at your girlfriend's house and tell the jury what happened.
So I woke up at my girlfriend's house. It was a regular morning. I woke up and took a shower. Then I got a text from my phone saying that somebody wanted to buy my phone for $600. And at the time I was selling a lot of phones, so that was a good thing. So everything was all cool. He was asking me the right questions. He was asking me the IMEI. Good. He was asking me if it was unlocked, and that made me know that he was serious. So once I knew that he was serious, pretty much I just asked where was he at, and then he sent me his location. He said, come to the Wendy's, and I was fine with that because one, you asking the right question, and the Wendy's is a safe space. You know what I'm saying? So pretty much I just said, can you? I said, let's meet there. So I met him, and when I got there,
This before you get to what happened when you got there.
Okay.
Some of these phones that you would purchase and sell, were some of them fake phones to your knowledge?
To my knowledge, some was, but at the same time, I used to sell a lot of phones in bulk and buy a lot of phones in bulk, and then plus just with the price amount of 200 and below, you don't know what you'll get out here.
Did you really concern yourself whether the phone was fake or real?
I mean, yeah, it could concern myself, but at the same time, it was all on the person who was buying it. If they, checked it out, they liked it, everything worked smooth with them, then it was a good transaction.
Did you ever try to sell a phone that didn't?
Nah.
Are there times that you sold a phone that may have looked like a iPhone, but really wasn't an iPhone?
I did that when I bought a pack of I bought 5 phones at once. After I left, he found out, and he told me that they were fake. So the reason how I sold that one, I just basically went to one of those people who have a lot of phones in their stores, and I had sold it to him in bulk. I let him know that it was fake. Everything was cool. He cashed me out, but when I say he cashed me out, I bought the phone for like 100, and he only paid 300 for it. So,
Turning back your attention to May 30th of 2018, when you got to the Wendy's, tell the jury what happened.
So when I got to the Wendy's, the dude was just waiting there. Josh, he was just waiting there for me. And then when I got there, everything was cool. He asked, "Can you check out the phone?" And I said, "You can." And then he asked about the IMEI. So with the iPhone, it's like some certain buttons you can press on when you call somebody to pop up an IMEI. So basically he did that, and then I checked it on my phone to make sure that everything was straight. And then he said that, and then he saw that it was active. So after that, he said, "All right, cool. Can I put my SIMS card in?"
Let me ask you this. When you traveled to this area, had you been to H.E. Holmes Drive before?
No, I've never been over there before.
Did you know who you were meeting?
No, sir.
The OfferUp account that you had, what name was it in?
I think the Brad Williams, I think.
Brad Williams, Isaiah Coggins?
Yeah.
Okay, and you weren't using your real name?
No, I wasn't.
Why not?
Because I sold a lot of phones. I used to buy at least 15, 20, every 2 weeks. So it was a lot of people that I was meeting up, and there was a lot of people that I had to call when I got to certain places. So I didn't want everybody just having my number, just calling me for more phones. So I just wanted to leave it at the transaction.
Okay. Given the fact that you didn't know or had never been to this area, did you understand generally where this area was at?
I didn't understand generally. I just knew that it was on the west side of Atlanta.
When you knew that it was on the west side of Atlanta, did you make any determination as to whether or not you were going to have a gun? Yeah,
that's when I decided to bring my gun, because I just knew that it was the west side of Atlanta is it can be kind of dangerous over there, kind of scary.
Okay, and where was your gun at when you pulled up?
When I pulled up, my gun was in my was right here. In my pocket. On my gun of my jacket.
What were you wearing?
I was wearing some slides. I was wearing some shorts. And I had on a black jacket.
You saw some video footage where a car pulled up at the corner of the Wendy's.
Yes.
And then there was the alleged victim meeting with that car.
Mm-hmm.
Was that you in that car, sir?
Yes, it was.
Okay. What car were you driving at the time?
My gray Kia.
Okay. And who got you that car?
My parents. I just got the car not too long before that. Before this happened, that was my first car that I ever had.
And were you helping pay the note?
Yeah, I was helping pay the note.
Were you helping on the insurance?
Yes.
Is that one of the reasons why you were trying to sell some phones for cash?
Yeah, definitely. And just being a young college kid trying to have fun.
Yeah. And so when you got there and he starts talking to you about the IME, I don't know what the number was.
IMEI.
Yeah, I'm a little old. I'm like a dinosaur. But when he started talking to you about that, tell the jury what happened next.
So basically, when he started talking to me about the IMEI, I check it from my phone. He checks it, see that everything's okay. Then he asked, "Can you put in his SIMS card?" So then, yeah, it's like a little thing, like an earring piece that you can take the SIM card out. So he was looking for that because he had to take the SIM card out of his phone. So whole time we doing that, he got to take out of his phone, put it in this phone. We got to turn the phone off, turn the phone on. Me and him just talking. I asked, where are you from? He told me Atlanta. I asked where. He asked where I'm from, and then I told him Decatur. Told him I went to Georgia State. I was like showing him different girls on Instagram, yada. But we was talking for a long time while he was turning his phone on, turning off. So when he finally turned it on, he gave a call to somebody. I don't know who it was, but it was just a call to see that it was activated. And then, pretty much he hung up the phone. He said, "All right, we're good to go." And when he said,
Prior to him saying you were good to go, at any time did he show you any cash during this entire exchange?
yeah, he flashed me like it was like 300, I think. He didn't count it in front of me, but he flashed it.
Did you ask him about the money and whether or not it was, how much were you asking for?
I was asking for 600, and then I asked, "Is that the whole 600?" And he said, "Yeah, the money good."
Okay. And then he checked out the phone and did all those things?
Yes,
And then he said, we're good to go.
good to go.
Okay. What happened after that?
So then he said he good to go. So then he was kind of moving kind of slow at that point because, we were just having a regular conversation. Everything was smooth. So he puts the phone in his back pocket, and then he reaches like he's finna hand me the money. And after he reached, he just took off real fast. He took off real fast.
Didn't pay for the phone.
Didn't pay for the phone.
So what's going through your mind?
Shocked, confused, because we were just having a good convo.
When he ran off, did you have the ability to step out of your car right then and there?
Yeah, I could have right there. I could have chased him. I could have shot at him, but like I said, that's not me. I do good business.
And then at some point, what'd you do?
At that point, I saw where he ran. So he ran one direction, and that's when I got in my car. I was already in my car, but that's when I pulled around. I pulled around the Wendy's driveway, and I came out the Wendy's and I made a right. And when I made that right, the only thing I saw right there was the rest of the road until like the highway. Then I saw the apartments right there. So
Is that where you saw him run?
yeah, that's where I saw him run.
At this point, why not just leave Justin?
I could have, but I just wanted my property back. At that point, I was mad. He didn't have nothing on him. I didn't see nothing on him. He didn't see nothing on me. He didn't seem too big of a threat. So I just wanted my property back.
When you got into the apartment complex, what'd you do?
When I got into the apartment complex, it's like a real big parking lot. So I pulled in, went like to the left a little bit, and then I went into a parking space. And then when I went to a parking space, I was just trying to see, just where he was at. So at that point, I'm not furious, man, but I'm just like, what's up? Where's my phone? I just got robbed. So now at this point, I get out of my car and I start walking around. It's like 5 buildings. So I start walking around. And then I give him a call. It rang the whole way. Nobody answered. So then I keep walking around, still just looking for him. And then I give him another call, because I'm trying to call him like, bro, I'm trying to do good business. Can you please just give me my phone back? I work hard for everything I get. So he never answered. So at that point, now
Let me ask you this. While you're looking for him, do you have your gun on your person?
it's on my person,
Okay.
but it wasn't on my hand or none. It wasn't out. It was just on my person.
Okay. Where was it at?
Right here in my taking.
You've heard some testimony that someone saw somebody walking with a gun. Was that person you?
Yeah, I mean, I think it was because I had my like the back of the gun is like kind of long. It was just a regular standard gun. So yeah, I'm not gonna say that, you know, that wasn't me.
I mean, did you have it out? Like, I mean.
No, I didn't have it out, but I had it right here, and you could kind of see it right there.
And so how long did you look for him?
I looked for him for like 20 minutes.
And you said during that time you called him twice.
Called him twice.
Did he ever respond?
Didn't respond.
Okay. And when he didn't respond and you couldn't find him, tell the jury what you did next.
So when I couldn't find him, it was nothing I could do at that point. It was purely nothing at all I can do. So I go back in my car, and you know, I was frustrated. So, you know, now I'm just, you know, cooling down, relaxing, got on Instagram, started looking at a couple events that was happening later on that night at Georgia State. So then I just leave, you know what I'm saying? There's nothing I can do, so I had to just leave. So now when I'm leaving, I see Josh come from, it's like a gate. And let's say I'm leaving the gate. I see Josh right here coming from the apartment to leave out the apartments. So now at this time, he doesn't even know it's me in my car. But basically I see him, and when I see him,
Does he walk by your car?
yeah, he walked right in front of my car. He didn't walk past my car. He walked right in front of my car. He could have just looked in and saw me, but he was just minding his business. And then
Did you notice anything different about him when he came out?
Yeah, he had a whole new outfit on. But I could tell it was him by his face, but he had a whole new outfit. So I knew exactly who it was. He had the same book bag, I think. So yeah, literally when he walked past my car, now at this point, this is when I stopped and I honked my horn because, you know, like I said, I'm not trying to hurt the boy at all, like at all. So I honked my horn and I park my car and I get out and I see him, and then I said, bruh, please give me my phone back. And then that's when, well, can I say what he said?
Well, you can say, yeah, I want you to say exactly what you said so this jury understands what you said. And I want you to say, with the court's permission, exactly what he said to you.
All right, so pretty much I said, bruh, well, I'm gonna say exactly what I said. I said, bruh, give me my fucking phone back. And then at that point, he looked at me, he was walking, stopped, looked at me and said, fuck you, and did like this. So, you know.
At that point in time, sir, could you have shot him?
Yeah.
How far away was he from?
About 15 feet, 10, 15 feet.
Okay, I'm walking towards you. Stop me in terms of how far he's from you.
Right here.
Okay. And did you pull out your gun at that time when he said F?
I didn't.
Did you try to fire your gun at that time
I didn't.
when he said F?
I didn't.
Why not?
Because I wasn't trying to kill him. I was trying to get my property back. I was trying to get my phone.
Okay, so when he said F you and motioned with his hand, tell the jury what happened next.
So when he did that, at that point, he said, fuck you. And then while he said, fuck you, he ran off to like this trail. It's like a trail from the apartments to the Wendy's. So he said, fuck you. And then he ran up the trail. And, you know, I'm right here, still wanting my property back. So I follow up the trail. So as I'm following up the trail, he's in the Wendy's parking lot at this time. And then when I get on the Wendy's parking lot, that's when I scream, or it's kind of yelling it kind of loud, like, bro, give me my shit back. You know what I'm saying? And then at that
point in time, how far is he away from you at that time?
I say about 20 to 25 feet at that time.
Could you have shot him at that time if you want?
Yes, sir.
And so why didn't you?
Because I just wanted my phone back. That's why I started to chase him.
So when you say, bro, give me my shit back, tell the jury what happens next.
So when I say, bro, get my shit back, he looked back at me again. And he say no, and that's when you take off. So, I used to play basketball, so I'm fast too. So that's when I started chasing after him. And then when I chased after him, only thing I did, I saw him look back and fire a shot, and that's when I stopped. And I fired one shot. And then after I did that, he just kept running. He ran across the street, and at his head, I remember at this time, I got my phone took. I lost some money, and somebody shot at me, and I'm scared. So
You shot at him too.
I mean, yeah, but yeah, pretty much I just shot at him. But that's what I was thinking about in my mind after the whole situation. Like, I just lost everything.
Would you have ever shot your gun if you didn't shoot at you?
No,
Doesn't seem like you were gonna catch him though, because he looked like he was real fast.
I mean, I'm kind of fast too. So
He had some slides on.
yeah,
Was that limited in your ability to run?
not really.
Okay. And so at this point, after shots are fired, tell the jury what you do.
So after shots were fired, pretty much like I said, it's nothing more that I can do.
After you fire your shot, do you see him?
No, I don't.
You don't see him continue to run?
Oh yeah, I see him run across the street, and then he just got out of my sight.
Did you think that he had been hit by your shot?
No, that was my first time ever shooting a gun.
Never been to the gun range and fire a gun?
No, I was too young at that time.
And at some point, after you shot and you see him run across the street, what do you do after that?
So after that, I just turned around and walk. Yeah, just really go back to my car.
You've seen some video footage of your vehicle traveling the same path as the alleged victim was running. You saw that, right?
Yeah.
That wasn't somebody else driving your vehicle, was it?
No, that was me. But
do you remember driving that path at that time?
at that day, I don't remember driving that path. But I can tell that is me on the video. But I came in one way, and I left the same exact way. So I guess that was just a quicker way to go home.
Well, when you say you left the same exact way, let me just try to be clear. You came down H.E. Homes and pulled into the Wendy's parking lot, right?
Mm-hmm.
You didn't come through the pharmacy, right?
Yeah.
I mean, so when you went through that pharmacy, that's not the exact route that you took when you came in, was it?
No.
Okay, and so do you recall taking that route as you left, sir?
I really don't. That was around 6 years ago or 5 years ago.
Do you remember who you were looking for when you took it? It had to be the victim. It was it not?
No, I don't think I was looking for the victim. I was scared at that time, and that's when I wanted to go.
Okay. So when you left, where'd you go?
I went home.
And after you went home, what'd you do?
I went home. I got some food from the food hall. Then I went to the recreation and played some basketball.
What'd you do with the gun?
The gun was the gun of the shooter.
What did you do with your gun, sir?
Well, my gun, I just took it back home.
And where is home?
Well, at the time I was living with my girlfriend, so I took it to my girlfriend's house.
And at that point in time, when you're at home, do you believe that you've actually shot and killed somebody?
No.
Okay. The following day, you get stopped by the police.
Yeah.
You recall that?
Yeah.
You heard Officer Gardner come in here and testify about that encounter.
Yes, sir.
And what were you doing at that time?
At that time, I was just selling another phone. That same morning, it was just like the morning before I got a notification saying that somebody wanted to buy my phone. They asked me the same questions. At this point, you know, I knew exactly where I was meeting them at. And I didn't bring my gun because of the day before. That was one of the craziest things that I ever, been a part of. So yeah, I just wanted to stay away from my gun.
Did that transaction happen without any complication or issue?
Yeah, that transaction was good. I was parked on the side of the street, but I already met him before. He went to he gave me the money because we met at a Waffle House, and then he checked everything and he said everything good, and he said he was gonna walk to an ATM. So he walked to an ATM, and I met him on the side of the street, and that's why he was just about to give me the money, and I was about to give him the phone because he already checked it out.
And what'd you do after that?
And that day was a regular day too. It was a nice sunny day. We had a pool, so yeah, me and my girlfriend were just chilling at the pool.
At some point, you learned that detectives wanted to talk to you, or that you were the suspect of a homicide investigation, didn't you?
Yes.
And did you and your family at that point hire a lawyer?
Yes, we did.
And at some point, were you arrested?
Mhm.
Huh?
I was arrested when I was arrested probably like a week after they told me about it, because within that week I went to turn myself in at APD, and then they said I was good to go.
Okay. Did you go and turn yourself in with a lawyer?
Yeah, I did.
What was it, Mr. Walker, at that time?
No, it was another it was like a family lawyer we have, just for like other like misdemeanor cases. So his name was Mr. Lee.
Okay. Did you meet with some detectives at that point?
Yes, I did.
And at that point in time, did they arrest you?
No, they didn't.
They released you.
Yes, it did.
Eventually, were warrants secured for your arrest, and were you arrested for murder?
Yes.
Where were you arrested?
I was arrested at my girlfriend's house in Ellenwood.
Were you arrested in California?
No.
Were you arrested in New York?
No, sir.
You were arrested right here in Georgia?
Yes, sir.
Were you running from anybody?
No, sir.
What have you been doing the last 5 years?
Right now, I own a real estate company where I teach people how to do wholesale real estate. I have around 120 students.
Objection, Your Honor. Irrelevant.
All right, I'll move on.
Sustained.
Were you trying to kill this boy?
No, I wasn't.
You know now that your bullet struck his back.
Yes.
What's your thought process about that?
I mean, like, sad, of course, when I went to the jail, people were saying how they saw, my face on the news. I mean, I didn't mean to kill nobody. I didn't mean to shoot at nobody. I didn't mean to do none of that. So I feel bad when they just showed me the autopsy, but I had just shed a couple tears because, like, I'm really sorry about this, but I didn't mean to kill anybody. I didn't mean to.
Would you have fired your gun, sir, had he not fired you?
No.
I can just have a look at it.
Video.
Those are my questions, Judge. I
Good afternoon, Mr. Carter.
Good afternoon, sir.
I want to start by talking about May 31st, the day you were pulled over. Okay. So you was pulled over by Officer Gardner, right? The person who came in here and testified. I guess that was Tuesday.
Yes, sir.
Okay. And you didn't have your driver's license on you, correct?
No, sir.
And he asked you for your name and birthday. Did he ask you that for that information?
Yes.
Okay. And whatever, but they weren't able to find you when they was not able to find your information when they looked you up. Is that accurate?
That's accurate.
Okay. All right. Somebody had to come and actually take your fingerprint to find out who you were, right?
Yes, sir.
Okay. That Glock firearm box that was in your car.
Yes.
Okay. The firearm you used to shoot Joshua with, did that gun come from that box?
Yes, sir.
Okay. And you had 3 cell phones in the car. Is that accurate?
Yes, sir.
Okay. And the officers, was it Officer Gardner or the other officer who asked you where you got the phones?
I think it was Officer Gardner.
Okay. And you told him that you bought the guns off the street for $250, right?
You mean the phones?
Yeah.
Yeah.
Okay, you told him that. All right. Now, you testified on direct that you would buy guns online. I mean, excuse me, phones online, correct?
Yeah.
Okay. But you told Officer Gardner that the phones in your car, you bought those from some guy off the street, right?
Yeah, it's different different ways I buy them because I normally buy them through websites, but if you go to Jimmy Carter and you go Jimmy Carter Boulevard and you go to different stores that people sell a lot of phones, a lot of people are outside trying to sell phones.
Okay. So those 3 phones, that's how you got them.
Yeah, those 3.
Okay. Now, on July 11th, 2018, you pled guilty in the state court of Fulton County to theft by deception, correct?
Yes.
Okay. And that related to an incident that occurred on June 4th when you sold a Mr. Tully a fake iPhone, correct?
Yes.
Okay. Now, you testified on direct that you was getting ready to leave the apartment complex and Joshua walked by you, right?
And walk in front of my car.
Walked in front of your car.
Yes, sir.
Okay. And you got out your car, right?
Mm-hmm.
With the gun in your pocket.
Yeah.
And matter of fact, let's do it this way. Pull up State's Exhibit 4. So for the record, I'm playing it at 10:15:40. Pause it for a second. Okay. Now, when did you say give me my shit back?
When I was,
When you was further back?
yeah,
Okay. And he's already quite a distance in front of you, correct?
he's probably like right here.
Okay.
See, that's when he slowed up. He was walking. I said, "Give me my shit back."
Okay.
See, by that time he was right there. No, I was right there. And he was like right there.
Okay. You run through those bushes, right?
Mm-hmm.
Okay. When it gets to the next screen, pause it for a second. All right. Play it at a quarter speed. All right, so no, well, hold on one second. So you watch this, pause.
Yes.
Okay. So you watched this video quite some times because played it like 3 or 4 times, right?
Mm-hmm.
All right. So I want you to show me where he turns around and fires a gun at you. Okay? Just tell us when to stop. Go ahead and play it.
Like right there.
Okay, we just can't see it on the video. That's what you're saying?
Yeah.
Okay, pause it for a second. Matter of fact, rewind it to that screen and then play it at full speed.
Right there, right there.
Okay. Pause. Now, when he fired at you, you saw him fire a gun at you.
Yeah.
You saw a gun in his hand
I got in his hand.
and he fired back at you.
I heard a gunshot.
And he's running at full speed, right?
Yeah.
Because we just saw that on the video.
Yeah.
Okay. So how does he, what hand is the gun in?
I don't remember. It was like 5 years ago. And it's like literally in the heat of the moment. I'm not looking at what hand. I don't remember. It was about 5 years ago. And it was the heat of the moment. I wasn't really looking at his hand.
But that was the first time that someone fired a gun at you, correct?
Yes, sir.
Okay. But it didn't stick out like in your mind to remember what hand it was in?
Yes, sir.
Okay. So he's running full speed. Did he fire back this way?
Yeah, it was either this way. It was either this way or that way. But he fired a gun. He fired a shot like that.
Okay, but you don't remember how he did it.
No, it was running. Well, kicking.
Yeah, go ahead.
It was running.
Mhm.
He did like this
He did like that.
while running full speed.
Okay. And he fired a shot at you.
A shot.
Okay. Just one shot.
Yes.
And then he kept on running.
Yes.
Okay. So while his back is to you, you pull out your gun and you shoot him.
Because I'm defending myself.
You said he fired one shot, right?
Mm-hmm.
And then he turned around and kept running. According to you, right?
Mm-hmm.
And then you shot.
And you have to say yes or no to
Oh.
the questions. That ain't gonna get it down.
All right. Yes, sir.
She's got to take down what you're saying.
I'm sorry, ma'am.
And so, and after, but when you shot, I mean, you was aiming at him, right?
I was aiming in his direction.
You was trying to shoot him.
I'm trying to scare him. You trying to scare me?
Say it again.
I was trying to scare him.
Okay. So he turned around and fired a shot at you.
Yes, sir.
Okay. And your response to that was to fire a shot at him, but not to hit him, just to scare him. That's what you're saying?
Well, basically, my response was to fire a shot at him
You was trying to shoot.
in his direction. Yes.
Not in his direction. You were trying to shoot him, right?
I was trying to shoot in his direction, sir.
So you weren't trying to shoot.
No, sir. I was trying to get my property back.
Why didn't you go get it? If the phone was so important to you, right?
Yeah.
After you shot at him, why didn't you keep after him to go and get your property back?
Because would you
Don't ask me questions. You can't ask me questions.
all right, well,
I'm asking you.
basically, if somebody's shooting at me, I'm not going to keep running after him.
All right. And that's because you're scared?
Yes, sir.
Okay. Play it back to that previous scene of the shooting. And before we play it, so when he fired his shot at you, that scared you, right?
It frightened me. Yes, sir.
Okay. And when you fired your shot back at him, you were still frightened.
I was still scared.
Okay. And you saw him, you believe he had a gun because he already fired a shot at you, right?
Yes, sir.
Okay. And you don't know where he is, right?
Right.
Okay. And now you're just walking away, right?
Yeah.
You turned your back to the person who fired a gun at you, correct?
Yes.
Okay. And you're just casually walking back to your car, right?
Because I see that he goes and leaves. He runs and leaves.
But he fired a shot at you.
Yeah.
You're in no hurry to get back to your car.
Oh, I'm in a hurry to get back in my car.
You're not running back to your car.
I'm walking fast.
You're okay. Pause it right here. Pause. And go back to the beginning of that, play it at a quarter speed. So at this point, according to you, you had your phone stolen, right?
Okay.
That's right. Okay. You had a shot fired at you, right?
Yes, sir.
And how many phones did you have? Was it just the one phone or multiple phones in your car?
That day it was just that phone and my personal phone.
Okay. And so you had your personal phone on you because you had called them.
Mm-hmm.
Looking for them. You didn't call 911, right?
Right.
Okay. Play that at a quarter speed. Oh no, not that one. Go forward. To the next time you see that camera. Yeah. No matter of fact, Yeah, just let it play. Is it playing? Yeah, we play. So in this next frame, we're gonna see a police car pull up in front of the Wendy's, right?
Mm-hmm.
While they're doing that, you're driving the wrong way through the CVS parking lot, right?
Yes.
It didn't occur to you to go to that police officer that's right there and say, hey, this dude stole my phone and shot at me. You didn't do that.
No, I didn't do that.
So then you leave there and go back to your girlfriend's house, you said?
Yes, sir.
Okay. After having been robbed and having been shot at, right?
Yes, sir.
And you having to shoot back, right?
Yes, sir.
And what you did was went home, right?
Yes, sir.
Got food, right?
Yes, sir.
And played basketball.
Yes, sir.
Okay. And so the next morning when you get up to go sell another phone, right?
Yes, sir.
Okay. And because the day before when you were selling phones, you got robbed.
Judge, I would object to ask and answer. And he's gone over this several times.
I'm entitled to a thorough and consistent
That
cross-examination
doesn't
now.
mean you get to ask it 50 times.
All right, he gets some leeway. Overruled.
Okay. So we're at the next morning. That was the day after you got robbed, shot at, and you shot at somebody, right?
Yes, sir.
Okay. But this time you didn't bring your gun.
No.
And when asked on direct, you said, I didn't bring my gun because of the day before.
Mm-hmm.
Okay. But the day before, according to you, you did nothing wrong, correct?
You said nothing wrong.
Well, you're saying you only shot Joshua because he shot at you, right?
Yes.
Okay, so that gun saved your life, right?
It defended me.
Okay. But the day after you had to defend yourself, you decide to leave your gun home, right?
Yes, because of a reason. Can I explain?
You sure can.
All right, I left it because I met him, and if you can look at the police on report, it was literally one street from Courtroom Street. It's a difference from going from my house to where I know it's safe and I know it's a college campus rather than Martin Luther King. So yeah, I was very, very safe on the college campus.
Where's the gun at right now?
The gun was stolen, I think like 4 days after, and I have everything to prove it.
The gun was stolen. You reported the gun stolen?
Oh no, I didn't report the gun stolen.
What do you mean you got everything to prove it?
Pretty much when I had made another sale on OfferUp, it was on 5 miles. I made a sale and I was selling somebody a phone for $600.
Where were you then?
I was right on Piedmont, right in front of the Willie's up on Georgia State.
Downtown Georgia State?
Yes, sir.
Where you feel comfortable?
Yeah.
You took your gun with you that time?
Yeah, I did.
Okay. So you took your gun 4 days later because for whatever reason, 4 days later, you felt like you needed your gun.
Yeah, and when I first stated, I said that I take it with me sometimes, not all the time.
Right. So because you didn't take it the day after because of what happened the day before, right?
Yes, sir.
And you didn't need it because you felt safe.
Yes.
Okay. But when I ask you where the gun is, your answer is, oh, well, somebody stole it, right?
Yeah, somebody stole it.
Okay, and this is the time when somebody stole it, 4 days later, right?
Yeah, 4 days later.
Okay, and you're downtown where you feel safe, right?
I
Which
was,
state campus?
yeah, but when I say by the Willies, it's closer to
Mr.
Gresham.
Collier, Mr. Collier, hold on a second. Mr. Lee, please, let's not interrupt each other. Mr. Collier, don't answer until he's done asking the question, and Mr. Lee, vice versa. Please proceed, Mr. Lee.
I'm gonna ask it again.
4 days later,
Yeah,
when the gun got stolen, why'd you bring it with you?
because then I was right there by Willie's on Piedmont, so that's right in between Auburn and it's another like a party street that everybody goes to in Atlanta. And yes, over there is kind of dangerous. It's still close to Georgia State College campus, but it's still dangerous.
And you reported it stolen?
No, I didn't report it stolen.
How did you get the gun?
I got the gun from a friend in the neighborhood and on the indicator.
You just bought it from a friend of yours?
Yeah,
A gun? Okay.
because I was selling phones at the moment. I just wanted to protect myself.
Mm-hmm.
I was getting a little successful with it.
So when you say you can prove that it was stolen, how you doing that?
Well, basically, I had to. So what happened was, I was making a sale to sell a phone for $600, and a guy had saw the butt of my gun. So pretty much he just asked, "Can I buy the phone and the gun?" So, being young and naive, I was 19 at the time. I said, "Yeah," and then he said he'd give me $1,500. He took out $1,500 and he had it all in cash and he gave it to me. And then he said, "Let me see the gun," because I already gave him the phone. So just being naive, he grabbed the gun and he stuck me up, and he pointed the gun at me, and then he took my real phone as well. And the proof of what I said, that is, I have proof of me getting a new phone ordered to me.
Okay. So wait a minute. So 4 days later, after you're robbed and getting shot at, you decide you no longer need a gun for protection. You'll just go ahead and sell it.
I mean, yeah, because it was for $900.
Hold up, Mr. Collier, Mr. Collier.
It states his testimony. It's not what he said.
Mr. Lee, what's the question?
He was explaining how his gun got stolen, and I recall his testimony being, and correct me if I don't mean to.
All right, we'll let him answer the question if it's not accurate.
Okay. Didn't you say a few seconds ago that the way your gun got stolen from you is you met some guy near let's call it the Willies?
Mm-hmm.
Okay, you met some guy near the Willies to sell a phone,
Yes,
right? And you had your gun kind of sticking out,
Mm-hmm.
right? And he said, "Hey, can I go ahead and buy your gun too?"
Yeah.
Okay. And you agreed, being naive, you agreed to sell it to him.
Yes, because
Let him finish. Let him finish.
You said yes, but Mr.
Oh,
Collier, you can finish
go
your but.
Yes, because I bought the gun for $300 and he was asking to buy it for me for $900. So that was $600 extra that I would have took.
Okay. So you sold away your protection, correct? Or well, that was your intent.
Yeah.
Okay.
At that time, because I mean it was a great deal. Why not?
Because you just got shot 4 days early. You didn't think you needed it.
Objection, that's not his testimony.
It's a avenue for cross-examination. Mr. Lee, you continue. Overruled.
Can you repeat the question?
I'll move on. Don't worry about it. And so, and the way that you can prove that that gun was stolen.
Well, it's not a way that I can prove that the actual gun was stolen, but I can actually prove that I had to get a replacement phone from Sprint.
Okay. So we just have to believe you, right?
Yes. Yes, sir.
Okay. Okay. Your Honor, maybe approach.
So we don't pay attention. I'm not gonna get outside of the jury. So they can really say something.
You very well just said.
Yeah, so I don't know what it's gonna say.
Right. Do you have a witness who told the call?
I don't know. No, they're not. I don't know.
Okay.
So wait, that's my, when you say you don't know if they're here or not, who would authenticate it and are they out in the hall? Yeah, then they're not out in the hall.
So you got more witnesses.
Yeah, he might be in the office. I mean, if he can listen to the call, that's his voice, that's his voice. I mean, if it's not, he can say it's not.
I think that's a proper identification. All right, let me call you. Well, here's the problem. I'm not sure how long it's for. Sure. So what's the next step? Okay. Well, why are the witness to see if he's the one? Okay. All right, members of the jury, we need to take 15 minutes to handle some business on our own, and we will be back with you then. Thank you.
All right.
Am I still on this time?
Yes, stay up here, please. All right, Mr. Lee, why don't you tell us which exhibits, have a seat, Mr. Collier.
It would be,
What would be the number of these exhibits you're seeking to introduce?
the number would be 57.
I think we're on 56.
Well, 56 is going to be the certified conviction.
Okay.
The ISO of the jail calls is on one USB.
Okay.
So
Yeah, so it's on one USB drive.
All right,
There's 2
57.
calls on one drive, so we'll make it 57.
All right, well, why don't we tee up the first call and describe it for the record, based, I guess, by its file name.
yeah, we can, you want to tee it up on your computer since it's sharing.
Sure, that's fine.
But just make sure you get the check button before you pull out that flash drive.
Yeah, I know.
There's got to be some initial proffer as to why they believe that these are his calls, Judge. I mean, can we have that proffer for the record?
And Your Honor, Brian Trepney on behalf of the state, at the beginning of the calls, he indicates that his name is Justin Collier.
Well, that's a pretty good proffer. I mean,
All right, and who's the individual, can you glean that he may be talking to?
It's a number that he calls twice. I'm not sure who the individual is. But I do know that in each of the calls, within the first 2 minutes, in one of them, he indicates that he did not shoot anybody. And the second, he says that there's no evidence against him. He didn't shoot anybody,
Right.
and indicates that he was somebody else that day.
All right, let's take it from the top and we'll play it and then play it from the very beginning of the video, since apparently these statements occur early on, sorry, audio. And then you let me know when you would indicate that you'd stop. We'll go a little further until we decide we think they've either moved on to discussing something else entirely.
Mr. Collier,
Yes, sir.
when you got arrested, did you spend some time in jail before being released on bond?
Yes, sir.
Okay.
Yeah, so the date is July 18th, 2018 at 08:54 and 35. The called number is 678-308-9558.
An inmate at Fulton County Jail. This call is subject to recording and monitoring, and your location information may be collected and used by corrections and law enforcement personnel. To accept this free call, press 1. To refuse this free call, thank you for using Securus. You may start the conversation now.
Yo. Shit, I really don't know. I think I just lost a connection. Hey, look who on the phone though. Uncle on the phone. I said Uncle on the phone. Oh, for real? Hey, look, I need you to do something for me. Hello? I don't even know that nigga. What's up, What's up, man? What's up, man? Shit cool. Man, y'all niggas just trying to hold up in this bitch, man. That's all I can do. Hold up and stay prayed up. Yeah. You still in there, right? Hell yeah. Right street. Damn. You want me to come down there? You want me to come defend you? Huh? Want me to come defend you? Oh yeah, but it's like these folks so lame. It's like they only do video chats. Like even if
That's your voice? That's you?
Well, hold up, Mr. Lee. Let's play it all the way through
Oh, I'm
the
sorry.
portion of, just because, so we keep it clear. And then when you're done, after that, we can stop and take those authentication questions.
Sorry, Jan, I wasn't.
No, that's fine.
I know, I'm trying to be a lawyer. Oh yeah, hell yeah. My lawyer come see me every week, really.
Nah, I come down there and visit you and shit if you want to.
Oh shit, hell yeah. I mean, goddamn, anytime. I'm just in this bitch just waiting, really. But I mean, I can't really talk about my case, but my lawyer, like, he gave me some of the best information to where I'm not even facing as much as I thought I was facing. So, like, I'm gonna fight this bitch. But, I mean, I'm innocent, though, you know. I ain't shoot nobody, so, like, I'm gonna be good.
All right, and let's just let's play it for an additional minute or two. We'll play it for an additional minute and see where that leads us.
Hey man, I need a favor too. I ain't been later on. I need to take Tip to the Walmart. She gotta get some milk. Well, unless you want to go get it for her.
It don't matter. I know you know it.
All right, come on and sleep. She ain't really trying to get up right now, but I'm just putting it in the house. So if you want to do it now, get her some milk. She got the money. Yeah, you already put in something on this. I really had to come get you gas. Huh?
I let me know how to do it or whatever.
Come on the phone.
Oh, I got you.
All right. And Mr. Lee, why don't you see if you can authenticate it from there?
Sorry, is that you?
Yes, it was.
Who are you talking to?
I was talking to my friend Amos.
Okay. And you made that call from the Fulton County jail facility?
Yes, sir.
I think it's authenticated.
But
He said it was him who he was talking to.
can I explain the call?
No, that's not where we are right now, Mr. Collier. Mr. Banks.
Look, he's recognized his voice. I still have other issues with the call. I mean, it's talking about, information that was provided to his lawyer, which is not really relevant to these proceedings and could have a prejudicial effect on the jury. And then two, Judge, frankly, if his defense was I didn't do it, and then they have this call, it would be a self-serving statement. And now they're trying to, in some respect, play a self-serving statement that I didn't do it to make it seem like he's now coming in and saying that I did do it and his story is changing. And so
That's exactly what they're doing.
well,
What's wrong with that?
I think it's objectionable. I mean,
But
on the one
on
hand,
what grounds?
on the grounds that one,
Can't make any comments.
it's a self-serving statement. He has the presumption of innocence right there. And ultimately, I'll deal with it on cross. I'll deal with it on cross.
I think that'd be the way to do it. But I think in terms of a hearsay, it'd be an admission by a party opponent. And in terms of relevance, it's him making a statement about what happened. And in terms of privilege with attorney-client, he's waived that by talking to someone else on a recorded call. So I wouldn't see, that's at least how I see it. But so at this point, do you have any concerns though about if once tendered, any other objections you would make towards its admissibility or authentication for this one phone call?
I just don't see how it's relevant to the issue, Judge. So
right.
Beyond that, I don't have any other objections.
Okay, objections on relevance for that first call is noted for the record. Why don't we deal with the second call then, since we're still dealing with the authentication, and we'll see how that one sounds as well.
Yes, Sean.
And Your Honor, this is listed as call 212 on July 23rd, 2018. The call time is 18:25 and 25. The dialed number is 678-308-9558.
Hello, this is a free call from
Justin Target.
an inmate at Fulton County Jail. This call is subject to recording and monitoring, and your location information may be collected and used by corrections and law enforcement personnel. To accept this free call, press 1. To refuse this free call, thank you for using Securus. You may start the conversation now.
Yo. Yo.
Hey, motherfucker.
What's up, motherfucker?
Hey, motherfucker. You get some money and goddamn disappear. Yeah, you get some money and
I'm trying to call
disappear.
you every day.
Nigga, I'm just playing. I'm just playing.
You give me some money and disappear.
Bro, you know, it be like that sometimes, bro. Man, what the hell you doing, bro?
We focusing on bullshit and that.
Shit, I heard the good news, though.
What?
Yeah, I heard you got like, what, 30 more days, 60 more days?
I got 53 more days.
Ah, that more on that count, but
Nah, but you feel me? I might be able to get out in 23 days, but it's not 23 days. It's gonna be 53 days.
hey, it's all good, cause I think if you do the 20, I think you come out of bond. But if your ass, if they do the 90, you know, you like home free, you ain't even gotta come back to you.
Yeah, you're right.
You ain't even gotta worry about it.
No, I mean, the 90 is when they have to give me a bond.
I mean, that's what I'm saying. That's when they ain't found no evidence too. They don't have no evidence to hold you.
Yeah. But
That's what I'm saying.
they really don't, cause I ain't do shit, so they really sitting for no
I know. Girl, you was with me. I'm like, what the fuck?
Exactly.
But
But
anyway,
it's all good.
Hey.
It's all good.
shit, your pot head.
Yeah, you.
And so that's going to be where you would pause it, Mr. Lee. Let's go an additional minute just to make sure we're not missing any context.
Okay.
Girlfriend and wife got some weed 2 minutes ago.
For
Hell yeah.
man, waiting on you. I'm gonna have shit in motion when I get out.
Hey, I'm trying. These niggas be capping. I had to do it on my own.
But
Hey.
it's alright, so
Guess what?
you probably get
Guess what?
$350 a
Guess
day.
what? Guess what?
What?
Guess what, nigga? I got that nigga doing the drop this tape. He dropped this tape today. Another day in person.
No!
Yeah.
No! What that shit called?
No cap.
Okay.
All right, let's pause it there, Mr. Lee. And to your knowledge and information, Mr. Lee, do they resume discussing the case at all?
Mr. Trevinier will have to answer that.
Mr. Trepanier?
To my knowledge and listening to it, I did not hear them discussing the case anything in any relevant way after that. They talk about not being out and missing things and things like that.
All right. And so, Mr. Lee, if you want to lay your questions here while we're hearing the witness on the authentication.
So in that phone call, Justin, you're talking to the same person, right? Your friend?
Yeah.
Okay. That's you talking to him, right?
Mm-hmm.
Okay. Is that a yes?
Oh, yes, sir.
I think that's sufficient foundation.
Well, we'll see. Any objection to the second phone call?
So having listened to the second one and also thinking about the first one, Judge, I would lodge a general objection. You know, if they're seeking to impeach him, they, you know, I mean, if, for example, he asked the question, weren't you on the jailhouse phone and didn't you say you didn't shoot him? And he says, no, I never said that. Then he could get it in through impeachment if that's what they're trying to do. But at this point in time, that predicate question hasn't been asked and that foundation hasn't been asked. And so those would be my overall objections to both the first and the second recording. And so I know you've overruled it on my objection to relevance. And having said that, my learned counsel whispered in my ear about impeachment, and I feel the obligation to raise it on that objection as well on both calls.
All right. No, I mean, I think that's a fair point. And that is, I think, also another exception to the hearsay rule here, that it'd be an impeachment by contradiction. But I think the first thing would be, let's cross the thresholds one at a time, which is, is there any objection based on the authentication and the foundation?
No, he's laid the top proper foundation.
All right. So then, so assuming these calls are established that hurdle, I think we've said there's the hearsay and privilege issues I've ruled on, and I think they're the same ruling for both of them. And now it seems like the challenge you're raising is kind of the procedural mechanism. And let me see if I characterize this accurately. It's that once he asks, is your position that if Mr. Collier then admits that he made an inconsistent statement, that the state cannot then publish these exhibits?
Yeah. I would submit that if it's offered for the purpose of impeachment, which the court even indicated, that's exactly what they're trying to do. I said that they were trying to impeach him because he's now coming here and saying ultimately that he did shoot, and before he said that he didn't shoot. Well, he's got to ask that question. Did you say while you were locked up in the jail that you didn't shoot anybody? And if Mr. Collier says no to that, then they can play the statement. That would be the proper way to impeach the person. If he says yes to that, then ultimately it wouldn't be played as substantive evidence. I mean, there's nothing to impeach. He's admitted to saying the very thing that they're now trying to impeach him on, and it wouldn't be impeachment.
Mr. Lee, any thoughts on the ability, depending on how this goes? Let's assume that he admits that he made the statement. What would then your position be on whether you can then play the call?
My position is that he's already given a prior inconsistent statement through his direct testimony and cross. So I can play the prior inconsistent statement through any, that I'm not limited to him either admitted on the stand and, or me playing it on the call.
I mean, that's my initial impression, just based on memory, and I'm trying to.
And I would like, just so we don't create a reversible issue, if I could just have, I don't think it'll be.
Yeah, we'll take a minute as well. And one thing I'm just seeing offhand, consulting Milich's handbook is when a witness admits a prior statement that is in writing, writing is admissible into evidence. And this is Duckworth, 268 Georgia 566. And I'll keep looking, but I wouldn't see a distinguishing feature between something being in writing, whether it's audio recorded. So essentially the last kind of question we're at is, even if he admits the inconsistency, is the state still able to introduce that extrinsic evidence showing the inconsistency? And my initial impression was yes, and that was my understanding of it, but we can take a minute here to consult. You have to stay right here, unless you have to use the restroom.
What you find over there?
Yeah, and for council, I'm looking at 613, rule 613B seems to be just reading the rule itself pretty much on point.
Yeah, I was just on that as you were saying it. So
We need to change the rules. Let me get there.
just go by statutes.
Thank you.
Oh, you don't think I can? Oh, because he first given an opportunity to, but then once he does that, so then I can do it. That'd be great. Just write down the dates of the two calls from what he said in general.
For example, that's my computer. I lied. Sorry. I need to go get mine.
All right, so 613B seems pretty much on point. Is there any where it mentions that extrinsic evidence, which is what we're talking about here in the jail calls, is not admissible unless the witness is first afforded an opportunity to explain or deny. And I read that, and that says that after, essentially construing that would be after afforded an opportunity, there's nothing barring extrinsic evidence at that point. Anything else, Mr. Banks, on that point?
Nope.
All right. So any other reason we can't bring the jury back in to continue the cross?
I'd like to use the restroom if I can, if that's okay.
Yeah, let's take a tight three.
Take three.
Here we go.
No, take three or Jordan.
All right.
That's what they did.
Objections. No idea what it's like. I mean, honestly, all that would mean though. He didn't testify. They could still do it. Carving out the exception for a party at home, it's not limiting. It's not saying you can't introduce any extrinsic evidence.
That's how I read it,
See what I
just
mean?
because.
No subsection shall not apply. So like this whole thing. What is it? One D2 is yeah. Looked it up a while. It has always come in. I haven't had to put my finger on the rule. Really?
I'm just trying.
Yeah. Really? It's a good gig. Why would I give it up? Oh. Well, you hired. Well, actually, I thought it was voters next year. What's that? Oh, okay. Yeah, that was my
Thank you. Thank you.
Trout on and stuff. Yeah. Yeah. That's what you're telling me. I got you. All right, are we ready, y'all?
Hey, you know, I just think I see it back.
Okay.
I just, you know,
Okay, let's go ahead and bring back in the jury.
All right, Mr. Jury.
Thank you, everybody. Mr. Lee, you may proceed.
Mr. Collier,
Yes, sir.
when you were arrested for this incident that you are on trial for, you were initially taken to the Fulton County Jail.
Yes, sir.
Okay. And you were given a PIN number that gave you the ability to make phone calls from the jail?
Yes, sir.
Okay. And on July 18th, you made a phone call to a friend of yours named Amos?
Yes, sir.
Okay. And when you called Amos, did you tell him that you were innocent and you didn't shoot anybody?
Yes, sir. And I told him that because it's on the jail phone. I didn't want to incriminate myself, if that makes sense.
Okay. And on July 23rd, right, you were talking to Amos again?
Yes, sir.
Okay. And you told him that you didn't do shit. They don't have any evidence, right?
Correct.
And then he said to you, that's right, or I know because you was with me, right?
Yes, sir.
And you said, yeah, right?
Yes, sir.
Okay.
Talking to my friend,
Okay.
over a jail phone.
Okay. I'm playing what we're marking as states exhibit. What are we on? 57, right? Marking is 57. Yes. I'm gonna seek to admit states 57 into evidence at this time and ask for permission to publish.
All right, with the previously noted objections renewed and overruled, they're admitted.
Okay.
Hello, this is a free call from
Justin Collier.
an inmate at Fulton County Jail. This call is subject to recording and monitoring, and your location information may be collected and used by corrections and law enforcement personnel. To accept this free call, press 1. To refuse this free call, thank you for using Securus. You may start the conversation now.
Yo.
Yeah.
Shit, I really don't know. I think I just lost a connection. Hey, look who on the phone though. Uncle on the phone. I said Uncle on the phone. Oh, for real?
Hey, look, I need you to do something for me.
Hello? I don't even know that nigga. What's up,
What's up, man?
What's up, man?
Shit, cool.
Man, y'all niggas just trying to hold up in this bitch, man. That's all I can do. Hold up and stay prayed up.
Yeah. You still in there, right?
Hell yeah. Right street.
Damn. You want me to come down there? You want me to come defend you?
Huh?
Want me to come defend you?
Oh yeah, but it's like these folks so lame. It's like they only do video chats. Like even if you come down here, y'all can only do a video chat.
Yeah, I know. I'm trying to be a lawyer.
Oh yeah, hell yeah. My lawyer come see me every week, really.
Nah, I come down there and visit you and shit if you want me.
Oh shit, hell yeah. I mean, goddamn, anytime. I'm just in this bitch just waiting, really. But I mean, I can't really talk about my case, but my lawyer, like, he gave me some of the best information to where I'm not even facing as much as I thought I was facing. So, like, I'm gonna fight this bitch. But, I mean, I'm innocent, though, you know. I ain't shoot nobody, so, like, I'm gonna.
And that was the July 18th call Now the
State was published the July 23rd, 2018.
This is a free call from
Justin Collier.
an inmate at Fulton County Jail. This call is subject to recording and monitoring, and your location information may be collected and used by corrections and law enforcement personnel. To accept this free call, press 1. To refuse this free call, thank you for using Securus. You may start the conversation now.
Yo.
Hey, motherfucker.
What's up, motherfucker?
Hey, motherfucker. You get some money and goddamn disappear. I mean, you get some money and
I try to call
disappear.
you every day.
Nigga, I'm just playing.
You give me some money and disappear.
Bro, you know, it be like that sometimes, bro. Man, what the hell you doing, bro?
A bit chilling. We focusing on bullshit and that bit.
Shit, I heard the good news, though.
What?
Yeah, I heard you got like, what, 30 more days, 50 more days?
I got 53 more days.
That boy on that count, but
But you feel me? I might be able to get out in 23 days, but it's not 23 days. It's gonna be 50 days.
hey, it's all good, cause I think if you do the 20, I think you come out of bond. But if your ass, if they do the 90, you know, you like home free. You ain't even gotta come back to you.
Yeah, you're right.
You ain't even gotta worry about it.
No, I mean, the 90 is when they have to give me a bond.
I mean, that's what I'm saying. That's when they ain't found no evidence too. They don't have no evidence to hold you.
Yeah. But
That's what I'm saying.
they really don't, cause I ain't do shit, so they really got me sitting for no reason.
I know. Girl, you was with me. I'm like, what the fuck?
Exactly.
But
But
anyway,
it's all good.
Hey.
It's all good.
shit, your pothead, girl.
And Your Honor, at this time, the state will seek to admit what's under States 56, which is a copy of a certified conviction from the state court of Fulton County, case number 18 CR 006-238, J as in John.
Objection to State's Exhibit 56.
No objection.
Admitted.
No further questions. Witnesses to the court.
Redirect, Mr. Banks.
Mr. Collier, excuse me,
Yes, sir.
explain what y'all are doing on the jailhouse folks.
Yeah, the first one, that was my friend Amos. I said I didn't shoot nobody. I was around people, and I didn't want to criminate myself as well. But I was around people who thugs and stuff. I didn't want to say I was, out here just doing all type of stuff.
Does what you said over the jail, did you know the call was being recorded?
Yes, I did.
Did your friend know the call was being recorded?
Yes, he did.
At some point, you were asked some questions about, you turned your back on someone who had just shot at you. Do you recall those questions by Mr. Lee?
Mm-hmm.
You have to answer yes.
Yes, sir.
You recall the questions of Mr. Lee where he talked to you about you turning your back on the alleged victim in this case.
Yes, sir.
Okay. Why'd you turn your back at that point?
Because at that point, I wanted to just go to my car and get away.
Was he still pointing a gun at you at the time you turned your back?
No, he was running away.
Okay. Had you fired your shot after? I mean, he had fired on you?
Yes, sir.
Did you fire more than once, Justin?
No. And
Sorry, is there something you want to share with Jerry?
yeah, and if you may, when I was the second phone call, my friend, me and him were obviously playing, playing around the whole phone call.
I knew you were asking questions about what you did
Mhm.
the day of the shooting and the day after. Going to get something to eat, playing basketball, and what else? What else did you do that day after this?
I went to the food hall, went to Georgia State Rec, played some ball. I probably, I don't know, I probably just went out that night and went to sleep.
Since the shooting, is that something that you think about every day?
Yes.
Were you trying to clear your head, on that day after the shooting?
Objection, leader.
What were you trying to do on the day after the shooting when you went to get something to eat, play basketball?
I honestly just had a regular day. I didn't know I didn't know the shot was connected.
At that point, did you have any idea that Joshua had died?
No, I didn't at all.
Those are my questions.
Can you recross on those particular points?
No, yeah.
All right, thank you, Mr. Collier. You can step down. Defense may call its next witness.
Judge, ladies and gentlemen of the jury, the defense rests. Thank you.
Does the state anticipate calling any witnesses in rebuttal?
One brief witness, Your Honor.
Are they available at this time?
Yes.
All right, any reason we can't proceed with rebuttal?
There may be an issue, Judge, that can we approach?
Is it on a motion or something else?
Yes. Well, not a motion, but.
Okay, we can approach. All right, statement called as witnesses in rebuttal.
State called Detective Kyle Kleinhans.
Later, raise your right hand for me. You swear or affirm that the testimony you're about to give to the courtroom is the truth, the whole truth, nothing but the truth?
Yes, I do.
You may be seated. State your first and last names, spell it out and speak about it.
Kyle Kleinhens, Kyle Kleinhenz.
Detective, thanks. Excuse me, Sergeant. Thanks for coming back. I only got about 2 or 3 questions for you.
Okay.
As lead investigator in this case, did you walk through the crime scene and look for potential evidence?
Yes, I did.
Okay. Did you search the area of where Joshua Torrance ultimately was found?
Yes.
Did you search the path observed on the video footage?
Other detectives did search
Okay.
that path, but I did not.
Okay. And did that path include the likely path taken by Joshua Torrance from, where, when he started running to where he ultimately fell?
Yes.
Okay. Did you find any firearms in that path?
No.
Did you find any firearm person?
No.
Did you find any firearms in the book bag?
No.
Did you find any firearms around Joshua's body?
No.
Did any of your designees, meaning the people that assisted you in this investigation, inform you that they had found any firearms associated with this case?
They did not.
Okay. I don't have any other questions, John.
Just because you didn't find a gun doesn't mean that a gun wasn't present. True?
True.
Okay. And in fact, you were the lead investigator in this case. Is that true?
Yes.
If you wanted to, you could have bagged and tagged the hands of the alleged victim to test those hands for gunshot residue powder. Is that true?
Yes.
You didn't do that, did you?
I did not.
And in fact, you could have submitted his clothing to the GBI for trace evidence testing or gunshot residue testing. True?
Yes.
You didn't do that, did you?
No, sir.
I understand that you didn't find a gun, but you could have done those investigative steps to determine whether or not there was gunshot residue on his clothing and on his hands. True?
True.
You didn't do that, right?
No, sir.
You saw the video footage in this case where Mr. Collier fired a shot at the alleged victim in this case. True?
Yes.
You would agree with me, sir, from your experience as a lead detective, that the gunshot residue powder from Mr. Collier's gun would not have ever fallen on the alleged victim in this case. True?
True.
Those are my questions.
I don't have any follow.
All right, thank you, Detective. Any further witnesses from the state?
No,
And so
I'm
does,
sorry, the state rests.
all right. All right, members of the jury, the evidence in this case is now closed. And so typically what happens next in this trial is we would proceed to closing arguments. Those typically will last anywhere in a case like this between 2 to 3 hours. So I don't think those are going to get done today. But I do think we may be able to start them so that we can get going Friday ahead of schedule. But before we can go into closing arguments, there are again some things that we have to do just between us and counsel. That will probably take, I would guess, between 20 to 30 minutes. All right. So if you wouldn't mind stepping back to the jury room, we'll be back with you.
All right. I'm always about stuff.
Okay. I'll put a sticker on it if you'd like me to. That was going to be courts too. All right, let me first, since Mr. Banks insists on making it apparent that I'm the new guy, I need to, I just want to clarify my ruling on sequestration after having the wisdom of Professor Milich and section 13.6.
I mean, no, I mean, I know you're well experienced, but you wear the robe.
Anyway, what I will say is that it does appear that although Rule 615 does not specifically address the conduct of how counsel should address witnesses, the case law does appear to indicate that counsel should not be indicating what the testimony has been in a case until a witness is excused, and that counsel should not excuse a witness if they think they might be recalling them in the rebuttal case. So that leads us to what the remedies are, and apparently a violation could lead to contempt. It could lead just allowing cross-examination, or it could lead to striking the testimony. And here, I think that I don't think it was actually fleshed out whether that actually occurred, but I think cross-examination was an adequate remedy based on the subject matter of what was covered on the rebuttal, just on the issue of a gun. But moving on, unless there's anything else to be heard on that, we'll move on to the charge conference. Are we ready for that? For the record, I'd already previously marked as Courts Exhibit 1 the joined indictment. And so Courts Exhibit 2, I'm marking as kind of the compilation that we can use as our working copy. We'll then strike, add to this, and I'll come up with a revised compiled copy that this would be the one after this is the one that we'll actually give to the jury during the deliberation. So this is more just so we're all going off the same page. This puts together both charges requested by counsel, as well as ones that court thought may also be applicable here. So we can go through them and use this opportunity to tailor it to the facts in the indictment at hand and get into the evidence itself. So I don't think, in the interest of time, I don't think it's necessary for everyone to just object when we get to a point if you think there's one that's objectionable. So we'll just go through them. Page 1, 2, and 3 are all the standard charges. Page 4 takes us to grave suspicion. And that's one that generally I look at pretty skeptically because the jury instructions tell us that it's unnecessary and it's already covered by presumption of innocence. So I'm inclined not to include it since it's already covered and it's duplicative. But if anyone, Mr. Banks, I think this might have been your request. I don't actually remember whose request was whose. Would anyone object to excluding grave suspicion?
No, Your Honor, we would actually move to.
Mr. Banks.
I don't have any objection to removing it, Judge. If I do, though, I mean, we're talking about this as if the court has already ruled on what my renewed motion would be.
No, that's fine. If you have a renewed motion, let's hear it.
So
I kind of barged ahead into the charge conference.
That's
so.
okay. I would just renew my motion to dismiss counts 1, which is malice murder. Judge, based upon the testimony of Mr. Collier, which I don't think has been sufficiently impeached. The reality is that there was clear provocation by the victim in this case. The victim did rob him of a cell phone. And ultimately even if the state says that should have calmed down, there was another encounter where words were exchanged and he's trying to chase him, has no duty to retreat at that point in time. I mean, can within the confines of the law, go and retrieve his property if he wants, chases the victim. And the testimony is that the victim shot at him. And so this is not a malice murder case. And I mean, based upon all the testimony and evidence presented, and I would submit that malice murder should not go forward alongside felony murder, Judge. Frankly, his testimony was that, I mean, he shot after being shot upon. If interestingly enough, the evidence, ballistic evidence, is that there was only one shell casing recovered that was shot from a 9mm shell casing, but there was more than one shot that was heard by the witnesses at the scene. I think one witness said he heard one shot while he was at the trash compact, and the closer witness, Miss Rebecca Jones, says she heard 2 shots fired, and that's what ultimately Justin testified to as well, that there were 2 shots fired, one being his, but his only being after. And so for all those reasons, Judge, I believe that he has established that, one, he was acting in self-defense, and we would move for a directed verdict on all of the charges. And at the very least, a directed verdict on 1 and 2 and 3, frankly. So
I'm curious. Obviously, I think usually directed verdict should be a straight acquittal as a matter of law. I don't know if I've seen it before where someone asked, instead of an acquittal on, it should be an acquittal on malice because what actually happened here was a voluntary. Is that's
what I'm saying?
Yeah.
And so to the extent that the court is inclined to dismiss the malice murder, I think it would be appropriate to instruct on the lesser include. I think that that's a fact issue for the jury. But when you have adequate provocation, Judge, which we do here, while the state wants to ignore it and didn't question the lead detective about the robbery and still hasn't, and doesn't want to talk about the robbery, didn't do it in the opening, didn't do it during the course of this case, he was robbed. But even still, let's assume there was some time that passed, right? That he could sufficiently argue that, hey, time passed, and after that 20 minutes or so, he didn't incite the passion that all that should have calmed down. There's another encounter, right? And that's uncontroverted. There's another encounter, and it's clear that there's another encounter because a chase ensues.
So I'm with you, and I think this kind of bleeds into the charge conference.
Sure.
But I think everything you've said, as I've been thinking about it and trying to review it, and obviously the state will have a chance to argue against it here, but it does seem to me that this is a case that calls for a charge on voluntary, and so I'm with you on those arguments. But what I was kind of more just inquiring about is just procedurally, it seems to me, I thought a motion for directed verdict is count one should go away entirely, not that count one should transform into voluntary based on some unknown power of the court. That's kind of what I was getting at, is it seems like directed verdict is all or nothing.
Well, I'm okay with that.
No, exactly. Unless you,
I mean, I'm okay with that.
it's purely curious to see if that actually is even an option. But frankly, for the reasons we talked about before, where just the standard of review on a directed verdict is all inferences are supposed to be in favor of the state. And so much of this, I think, is very much going to be within the province of the jury.
Okay.
So I believe the ruling would still stand there, despite the defense case in chief. All right. So turning back to the charge conference, we had talked about, we were on pages 5 and 6. Again, the standard charges. Reaching 7, I don't think we had any stipulations. So
We did have one,
which one was that?
the admission of the in-life photograph.
And that's where I kind of redirected.
Yeah,
Remember?
that's right. Yeah.
It wasn't so much a stipulation as it was he just did not object, and so it was admitted as an exhibit.
Okay.
Right.
Yeah.
So then we don't have to worry about written stipulations or any of that.
Right.
All right. All right. So then 8 and 9, credibility of witnesses are standard. Again, I don't really see anything that needs tailoring. At any point as I'm going through these and y'all want to add something, please stand up. Page 10, I believe one of the party asked for conflicts in testimony, and I don't believe that's still a current pattern charge. So unless I hear an objection, we'll strike that request, because I actually don't even think I have language for it.
I think it's covered in the credibility of witnesses. Okay.
All right. Page 11 is expert witnesses. I do believe now on page 12, I had it italicized just to see how the evidence presented itself. I do believe that there was impeachment now. And so we would include that. And on page 12, page 13, let me double check. I don't think we got into character or I don't know, or did we? I don't know. There was the prior conviction, but I don't think that would be considered opinion or reputation evidence. There are specific instances of conduct that came in through the prior conviction for theft by deception. So does anyone have any proposal of how to tailor witness attacked on page 13?
With that, on page 13, bad acts, 13140, would that not, the conviction not encompass bad acts on cross-examination only, that portion of it? Not sure what Mr. Banks's position would be as relates to that, but
I don't think this applies at this point.
Well, actually, you know what? It looks like we've cut off a lot of the pattern charge here. There's a lot more for it. So I think we need to show you the full text of 13140 actually includes a specific provision for a crime of dishonesty conviction. So proof that the witness has been convicted of a crime involving dishonesty. And I think that's how we could encompass that. Otherwise, I think would bias be cut. Do we think there's any evidence of bias here? All right, so I think what I would do here is we would strike the examples of character for untruthfulness and bias that are written on page 13, but from the pattern charge, there's a provision for crime of dishonesty conviction, and we'll include that one as falling in this phase. If that's agreeable to everyone, I'll move on to 14, which is witness supported. And I'm wondering again if this one is one we need to include. I don't think we got back into character or specific instances of conduct, and I don't know about bias either. All right, so any objections to striking witness supported on page 14 of the instructions?
No, yeah.
All right, and none for Mr. Banks?
No, Judge.
Okay, prior statements, I believe that has now come out, I think through the Detective Kleinheinz and his sworn affidavits, and now through Mr. Collier's testimony.
Yes.
And that, I think, as written applies. Page 16 is the pattern charge on single witness. And then turning to page 17, defendant's choice not to testify. I believe we would still keep the first sentence and just strike the second sentence after however. Or should we just strike the very last sentence if the defendant chooses not to testify, allowing
Yes.
the statement that the defendant does not have to present any evidence?
Yes, the word starts as however.
Okay. All right. So the only thing I would strike out of the pattern charge on page 17 would then be if the defendant chooses not to testify.
Well, yeah, actually.
Sure.
However, as well, because it's just not applicable now that he did testify.
Well, the only thought there is the defendant doesn't have to present evidence. That fact doesn't change whether he did or not. And so I think that is still something I'm sure could be argued at closing and relied upon. And yeah, so that was my thought there. All right, there were statements of the defendant in this case, I guess, from the traffic stop the following day. But I don't know. You'd have to remind me if there was ever any kind of pretrial Jackson Deno hearing or any challenge on voluntariness or anything. So I guess my question would be, do we still want to include the pattern charge of statement of a defendant on page 18?
Yeah, I mean, I think we played a very short portion of that call. I think the only statement he said was, y'all gonna get me over a phone? So I don't know if you want the charge just for that. I mean, he didn't say anything else. He wasn't asked anything. Officer Zabinski just took his fingerprint. She didn't ask him any questions. I think he was actually responding to maybe something previous the officer said before she arrived. But the only thing I ever heard him say was when he first got out the car was, "Are you really going to get me over a phone, bro?" Or some words to that effect. So
Yeah, I mean, we didn't challenge it at a pretrial hearing. We thought it was more of a spontaneous utterance that wasn't in response to interrogation, although he was detained. So we didn't file a motion.
So I guess what I'm seeing in my notes here is that it's not necessary to charge on the voluntariness of a confession unless there's a specific request for one. So I guess I'll just put the ball in your court, Mr. Banks.
Judge, I'm not asking for the charge. I'm sorry, man. I'm generally not told to speak up because I'm always so loud. Judge, I'm not requesting the charge.
All right. On 18, I think was more of a guidance charge anyways. There's really no language there. So 18 will not be included. 19, statement of a defendant, the pattern charge will not be included. And that takes us to page 20, limiting instructions. This wasn't requested by either party, but I think we ended up getting a limiting instruction if nothing more than just a passing comment on when something was sustained or overruled.
Okay.
But I'm at whatever the party's
I don't
thinking.
remember.
If we want to keep it out, we can keep it out. I don't think I did a formal direction.
I don't remember anything about a limiting instruction.
Yeah, actually, I think you're right. Thinking more about it. I guess limiting instruction is more than just ruling on the objections. It's a specific admonition about evidence before or after it comes in. So, all right, well, not hearing it from the parties, then without objection, I'll strike page 20, limiting instruction. Page 21, prior difficulties. Do we think any of that's here?
You had the two encounters, so I think, like in an abundance of caution, you may want to give that because you had the first encounter at 9:33, and then the second encounter at 10:15.
I don't feel strongly either way. I mean, I think that's all kind of the same day, same interaction. Prior difficulties, I always think of something prior in time, but
Yeah.
Well, I don't have.
That's kind of
have
how
to
I
have it.
feel about revenge too. I mean, I know we haven't gotten there yet, but I mean, any event, but prior difficulties seem to suggest that they've known each other and had some prior dealings. But this is their first encounter and only encounter.
all right. So just to clear it up, does the state want it in or not?
Well, I want the revenge instruction, so.
We'll get there, but
I mean, if the prior difficult, if removing the prior difficulties instruction.
no, removing that one has no bearing whatsoever on, we haven't gotten to revenge. I haven't even thought
Okay.
about that one. So
No,
solely prior difficulties. What do we want to do?
we don't have to add.
All right, so I'll strike page 21, prior difficulties. The next couple are dealing with identification. It seems like that is no longer at issue.
No.
So we will strike page 22 without objection and page 23. Page 24, although there were some general references to some prior conduct and that he's, I think, not about that life. I don't know if good character of the defendant is needed as a formal charge, but I'll hear that from, I don't remember which party requested this, so whoever wanted it can speak up now.
I know I didn't request that one.
Well,
Yeah, opinion of another.
introduce any character evidence other than the fact that he went to school and has been a law-abiding citizen for most of his life.
Right. I think this is speaking more to when you get other witnesses up to talk about opinion and that sort of thing. All right. So I'll strike 24. And now I think we get into more of the specific definitions. So we've got definition of a crime, standard instruction of intent on 26. No presumption of intent on 27. We then have presumptions and inferences on page 28. Again, these all seem to be all the standard charges that don't need tailoring. Taking us to 29, put mere presence in there just as a point of discussion, but I think at this point, it doesn't seem all too relevant.
Agreed.
All right. We'll strike page 29. We've got the standard charge of venue on page 30. We then get into malice murder on 31. Motive and felony murder on 32, 33. Again, nothing here. I think we've tailored on felony murder on page 33 solely with the underlying count of aggravated assault with a deadly weapon. And on 34, we have the felony murder more closely defined. I think we need to cut out, this is from another trial, the middle of that paragraph where we're talking about possession of a firearm. So we'll cut out this sentence where it says you may also find. And it'll pick back up with there must be some causal connection. Any issues with moving on? Seeing none. Page 35 gets us to voluntary manslaughter. So let me hear, let me hear the position of the state of whether voluntary manslaughter should come in here.
Your Honor, the state's position is voluntary manslaughter wouldn't come in at this point. I'd point Your Honor to Ruffin v. State, that's 296 Georgia 262. I have copies for counsel as well, and the court. And this would be on page 4 of 5, the left column under subsection B, about halfway down. It states that here appellant's own testimony contradicts a necessary element of voluntary manslaughter, and that he claims he did not intend to kill, but was acting in self-defense, and thus he was not entitled to a voluntary manslaughter jury charge. In this case, what I heard defendant say was that he never intended to kill the victim in this case, and therefore he would not be entitled to voluntary manslaughter.
Right. Okay. So I understand your argument. The standard we're dealing with is slight evidence. And so here's my initial thinking here is that if there had been no video and all we had was the defendant's testimony of what happened, I think I'd be more with you. But it seems like the jury could ignore completely what Justin Collier said and say, well, that video combined with the testimony of the detective saying this was a robbery introduces elements of provocation and the cooling off that it seems to me the case law says is the province of the jury. So that's, and this is absolutely reversible. So
Yes,
I hope
Judge.
you're very confident in your assertion
And
here.
I understand, Judge, and again, I do think, again, this is a post-conviction decision, and so understanding that obviously the procedural posture of the case is different, evaluating post-conviction versus here. Obviously, out of an abundance of caution, I do think it's probably better to give, but I don't think it is a necessary, it is 100% necessary based on the defendant's statements.
So are you opposed to giving it or are you not? What are we talking about?
Just give me.
Yeah, and I'd be curious how we would square this with this Ruffin case. What do we see as distinguishing the Ruffin case from this case?
I mean, I think the court's comments about the provocation distinguish it certainly. I think also too, I mean, he didn't just say, I didn't intend to kill him. I mean, when he said, look, I mean, he fired at me and I fired back. You know what I mean? Whether he intended really to kill him, I mean, he's certainly trying to neutralize the threat. I mean, so all of this is just really reasonable inferences that can be made, Judge. I mean,
But not based on his testimony though, because you have to have that provocation, and that's not what he was saying he did. He was acting in self. He didn't want to kill him. He was acting in self-defense.
yeah, I mean,
Involuntary manslaughter, it's I did it to kill him or to harm him or with,
I did it because I was in fear of being shot myself. I mean,
Yeah.
anybody, I mean, he says he's not about that life. I mean, suggesting that, I mean, did he really want all this to happen? That's how I take that, is that I didn't want to kill him. I mean, I mean, he said it repeatedly. I was just trying to get my phone, but ultimately he fired up on me and I fired back. And so, I mean, I think that's the narrow focus. I mean, added with the provocation. If we don't get this charge, Judge, we're going to be trying this case again. And so if that's what the court wants to do, I'm happy to do it, but I don't, I think out of an abundance of caution, I would just encourage, they can argue what they want to argue, but.
well, I think I cut off Mr. Trepannier's argument. So Mr. Trepanier, do you have any other case law, anything you want to add to it? I'm trying to skim Ruffin here to see if there's ability to distinguish between our two cases here.
I think to avoid any appellate issues, it may be better to give it and then allow, obviously, argument and closing to flesh out any intent issues that are present in the case.
All right. Okay, so then at this point, without objection from the state, and it's the defendant's request, and it's still the defendant's request, we'll give voluntary manslaughter on page 35. I'm looking at page 36 now, I'm just reading the bench note that's included here. Consider modifying the first sentence to require that the evidence must prove. I guess that's a fair point. So for the first sentence, that would read, for voluntary manslaughter, the evidence must prove that the defendant. We'll get you a verdict form as well to show you, but I think we'll deal with that when we get there. But it would include both as an alternative. Okay, anything else before moving on?
And I think you just addressed it, but I think voluntary manslaughter as a lesser included of felony murder as well. I believe it's necessary.
That would be on page 35 in the charge, and then we'll also make sure it's quite apparent on the verdict form as well. All right, I think we get to page 37, and now let's be very careful and make sure we're charging on the right aggravated assault. So we've indicted here shooting, so I don't believe 37 would really be applicable at all.
Agreed.
So I'll strike page 37. 30, that was page 37, assault with intent to commit a felony. All right, that takes us to aggravated assault with a deadly weapon. Do we believe this tracks the language of the indictment? There might be another one here, actually. I'm not. Okay, no, it's indicted as right there, aggravated assault with a deadly weapon. Any objections to page 38, aggravated assault with a deadly weapon is written here?
No.
All right, page 39, standard charge on firearm is a deadly weapon. Page 40, we've got possession of a firearm during the commission. And it includes our 3 felonies on the indictment. And then we turn to page 41, justification.
Yes, Your Honor.
Any thoughts or need to tailor justification as written on page 41?
I think it's the pattern, is it not?
It is the pattern, should be the pattern in its entirety. We'll double check it. Well, yes. There's a section of the pattern charge where it asks if we need to define other certain felonies. After 2B, the way the pattern charge reads is the commission of a forcible felony, which means a felony that involves the use or threat of force or violence against another. And then it has the extra bit here is blank as a felony, which I will define for you shortly. And my thought is that the forcible felony that the defense contends was happening would be aggravated assault, which we would have already defined.
Yes.
So we can just keep that out.
Okay.
All right. And then it looks like what we have here is also tailored somewhat from the pattern charge. So let me make it clear what we left out. We left out is attempting to commit, committing, or fleeing after attempting to commit a felony. I think that could be relevant here. So we need to put that one back in. And which felony would we want to?
Oh, wait a minute.
So it's you have to look at the pattern charge.
I'm looking at it.
So down there, a defendant is not justified in threatening or using force if he, and then there's 2 more bullet points. We've taken out combat by agreement. I think, is there any objection to taking out combat by agreement?
No.
All right. So then there's another one though, which is flight after a felony.
Okay, I'm trying to get to a judge. Hold on for a minute.
No problem. It's 3.10.10.
Okay. 3.10.10. Okay.
Well, I suppose that might also still not be relevant because
I don't think it's, I mean, look,
yeah, that no one's contending the defendant was committing a felony at the time, right? Because or fleeing from a felony is what I'm saying.
no. Right.
Because he wasn't.
Right. A defendant is not justified in threatening or using force if he is fleeing after attempting to commit a felony. That's basically what the, okay. Okay, so then 41, as we actually have it written here is what we're going to go with.
Okay.
Page 42, we've added in use of force in defense of property other than home. And this was to cover the issue of the stolen iPhone and some of those things that were brought up.
Yes.
So let's read that one carefully and see if it needs any tailoring.
I think it tracks with some difference the other one, just defensive person, but just involves property here. So I think it's appropriate.
All right, how should we deal with the parentheses then in number 3? Can we strike some of those out?
To stop.
Like the defendant's immediate family member or legal duty to protect. Those don't seem relevant here.
So someone else's property is not relevant. Property that is lawfully in the possession of a different, yeah, we can strike that. You can just say property that is lawfully, I'm sorry. I think the first parenthetical under paragraph 3 is appropriate, but the second and the third parentheticals are not relevant.
All right, I think I agree. Anything from the state?
Go ahead, you got, I mean, I agree with what you just said. So.
I don't know if we have slight evidence that would justify giving this charge if, as the evidence came out, the robbery that is at issue occurred at 9:30 and the justification as alleged by defense is the aggravate or the shooting at defendant. This charge, there's not property that is lawfully in the defendant's possession at this point, as there's been a period of 30 to 45 minutes in between. So I don't know if there's not slight evidence that would necessitate this charge.
I mean,
I think it's a fair point.
Well, let me just say is that, I mean, we're failing to address the elephant in the room. The issue of timing is one that needs to be decided by the jury, just like they will decide if he was justified and had the necessary passions under voluntary manslaughter. The reality is this: the alleged victim, and I keep calling him that because he was the instigator in this case. He robbed our client of his possessions, and so. I mean, the reality is that this was an ongoing conflict. It's not like our client went home and then rested and then came back hours later. This all happened within 30 minutes, Judge.
All right.
I mean, this is
fine.
ongoing.
No, I mean, I think that's a good point. We'll let the it's an ongoing activity that the defendant goes in search of the alleged victim and locates him, and I think we would ultimately likely get a jury question about it anyway. So,
and I think what your Honor is saying though is at that point, the property is not lawfully in the defendant's possession anymore, even based on what the court is indicating, what its ruling is based on. The fact that, okay, this is a continuing thing when the property is now with the victim, it is no longer in the defendant's possession, and there's a significant period of time there.
30 minutes is not significant.
well, so you stretch that out though. It's, you're saying that the second that if someone grabs your purse on the sidewalk, the second it gets off your shoulder, you're then hands off, no ability to go after it or pursue it or anything like that. There has to be some interval there where this is still relevant.
Well, and not only that, to prevent somebody from continuing to take property, I think is the court's point.
Oh, there's another one. If you had two purses after they take the first, I don't know. There's a lot percolating here, and I think there's at least slight evidence. All right, let's get to revenge on page 43. I think both sides wanted to have something to say on that.
Well, I guess if there's a lot percolating, I mean, I would object to its introduction, Judge. I just don't think it's relevant. Revenge is more of when there's not an ongoing conflict, something happens and then time passes. I mean, 30 minutes later is not a revengeful act. He's still looking for his property.
It says previous occasion, and that's what it says. So if there's slight evidence of property that's not in his possession for 30 minutes, there's definitely slight evidence of something happened on a previous occasion.
I know. I think we're now flipping sides here and arguing the inverse. And I think I think if we're adding in defensive property, then this one should come in as well. How should we tailor the parentheses? Imminent. I guess
Serious bodily injury. I guess the unlawful use of force would have already happened if he says that.
They're almost, if it's someone pointing a gun and firing at you, I think all four basically apply.
I would agree.
Well, actually, let me think through that again. Let me actually read it. And not for the purpose of preventing an imminent. They're almost synonyms in this situation, so we might as well just charge all four parentheses here. But I'm open to suggestions.
I think all four are appropriate, Judge. I will say, going back to justification and all that stuff, I don't know if I read in here that no duty to retreat.
Okay.
And that would be the pattern instruction 3.10 and 0.13.
At what point would you be contending that Mr. Collier stood his ground, though? I mean, the video seemed to suggest that there's a pursuit.
Well, yeah, he's pursuing him ultimately to get his property. But I mean, if you accept his testimony as true, he only shoots after. So he doesn't have a duty to retreat after being fired upon. And so he can stand his ground and return fire.
Your Honor, based on what counsel is saying though right there, I think that cuts against the use of force to protect property that's in your lawful possession. If you are pursuing somebody to get property back, it is no longer in your lawful possession, and therefore that justification charge shouldn't be given, because what he's arguing is the justification is related to the shot fired at him.
But the problem is that he's in corporeal possession because it's his property. It's just in somebody else's pocket. That's still his property. You negate that factor. It is still his property. It don't matter that he has it. It's still his.
But you don't have a right to pursue.
Yes, he does, because that's his property. He has a right to get his property back.
Okay.
If you take my keys, I got a right to come snatch them back out.
Mr. Walker. All right, save it for the closing.
I think he should do the closing, Judge.
And person is not the aggressor.
Give me a break.
Give you a break.
Yeah.
All right, I'll take a closer look at no duty to retreat. That seems maybe a bit of a stretch here when this is just it's a situation that really didn't, where the defendant was on the video in pursuit, but
okay.
I'll take another look at it. All right, moving on to page 44. Now we're just getting back into the pattern charges. We've got verdict generally.
Yep.
No interest in the case.
Yep.
Sympathy, sentencing, and in sympathy, I'll just keep in on, I guess I can take out or corporate status. I don't really see any point for that. And then that leaves us with deliberations and unanimous verdict and retire to the jury room. Okay. So as I mentioned, we'll consolidate all of these. We will have it without the headings, so it'll only end up being about 10 pages. And that'll be what we send back to the jury. So let me inquire, does the state intend to both do an opening and closing?
I was planning to, I would ask But I'm asking if you could start closing tomorrow. It's almost 4:00. There's a lot of, now that there are charges coming in that, I have to adjust the PowerPoint a bit. And, but I will say that now that there's not an issue of who did it, I expect my closing to be shorter than it previously was.
Sure.
So.
Mr. Banks?
Judge, I'm always begging for more time.
Don't I?
And I don't even know who's gonna do the closing after I heard just Ms. Walker ran a little bit. And so look, the jury will have it. We can start promptly at 9, I think.
Well, I have some motions that were scheduled at 9 a.m. They shouldn't take long. So I think we would start at 9:30,
All good.
just FYI.
Okay. I would respectfully request more time so that we can be short and concise and to the point.
And do you anticipate using the full 2 hours?
I don't think we'll need the full 2 hours because I do think that there's a narrow issue in this case that if we focus on that issue, frankly, I think we could sum it up in an hour.
All right. All right, so we start at 9:30. That would give us a good 2.5 hours to get through closings. I could charge them through lunch and then they could decide whether they want to work through lunch or break. So I think that sounds like a good plan of attack, and that'll give us time to consolidate the charges and get them back to you. So with that then, why don't we'll bring in the jury and excuse them for the day.
Is there a verdict form too that we can see, Judge?
We'll get that to you. I didn't print it off, but I already have one.
Okay, thank you.
And we can talk about that before
To the most of the.
for tomorrow.
Judge, if you want to set a great precedent, I think Judge Downs did this when she first began. We worked through lunch and she paid for lunch. So.
Oh, well, Fulton County is even more enlightened since Judge Downs. They actually have a whole fund. They will be getting lunch tomorrow. Courtesy of Jason.
Just not from your salary.
We'll have to provide the tip. So.
All right, jury.
All right, thank you, everybody. Members of the jury, thank you again, and as always, for your patience. After conferring with counsel and dealing with a few matters that we needed to take up, it seems to us that it would be cleaner and to do all the openings at once, back to back. And so I think that's going to conclude the business that we can do today together. I do have some motions on other cases that are scheduled for tomorrow morning. They should be very brief. So that being said, I don't think we would start until 9:30 tomorrow. So if you could please be here at 9:30, ready to go, and then we'll go right into closing arguments. A few more updates. What I would anticipate doing is we would have closings, and then at the conclusion of closings, it would then be around noon. And so we could you could either break for lunch, but what we're going to do is Fulton County is generous enough to offer lunch on the day of deliberations. So we're going to do an order with Jason's Deli. You don't have to use it if you don't want to, but we'll be ordering a collection of sandwiches and drinks and chips, etc. I think it's just the general turkey or ham, nothing too extravagant. So if you want to take advantage of that, feel free. But if not, you're always welcome to still bring your own or make your excursion out, whatever you as a jury start deciding you want to do during those deliberations. The time will then become your own. So with that, my last two instructions would be, please don't discuss this case with anyone or anywhere or about anything about this case until you're back here and you started deliberating, and don't do any research about this case whatsoever. So before I excuse you, I'll ask if there's anything else you think or any questions before we see each other again tomorrow. All right, seeing none, thank you again.
All right, to the jury.
Yo, what's up, bro? This shit is dead on point.
All right, we'll be in recess until tomorrow. 9:30. What's that? Yeah, I was gonna strip them out.
I'll take that up, because I'll take a, like, I'm gonna. Yeah, I'm gonna take a look.
It's all right. Yeah.
Right. Have a good night. See you later.
You know what he did?
The live stream's still on.
Yeah, wait. Let me just back up.
I'm sure you're large. That's kind of my like.
I think the only.
Yeah, I was thinking about that.
I don't think,
Just
I
worried
think
that's gonna hang. Anything hangs, it's gonna be that.
Yeah.
It's gonna be decided between those two things.
well, and my thought, like, it just seems very counterproductive, but I guess you can argue alternative theories. So I think maybe that's. Yeah, I guess if you're arguing That's what I started to think about is, okay, it's this, but assuming you don't believe this, then it's this. So. I can carry my computer, I just put it in there because. That's your flash drive right there.
It's such an important thing.
I didn't know what you're closing.
Oh, yeah, no, it's just.